I am muted. I'm sorry. I thought I unmuted myself. Well, that was really dumb. Hello, everyone. Welcome to Uncivil Law. I thought I unmuted myself and then apparently remuted myself. I'm an idiot. Welcome to Uncivil Law. For today's story, we turn our attention to the issue of guns in Mexico in the case of Smith & Wesson versus Estados Unidos Mexicanos. What a nice name. The Mexicans believe that the United States is responsible for gun violence that has been caused in Mexico, in particular Smith & Wesson, for their firearms that have made its way into Mexico, and would like to sue the United States, and more particularly Smith & Wesson, for the gun violence occurring in Mexico. Now, this, of course, raises many issues, one of which, of course, is standing, as Mexico has the ability to sue, which relates to international issues, and also, of course, the Protection of Lawful Commerce Act, which is an act that Congress passed in large part to stop gun manufacturers from being sued unless their product was defective. And so if the gun blows up in your hand or something like that, you can sue the firearm manufacturer for a product defect. You can do that. But you basically, the law in so many words prevents you from suing firearms manufacturers because their gun worked as intended and someone died. The gun worked properly. So the thing did what it was supposed to do. So you can't sue the firearms manufacturer for that. The US Congress passed a law. There are exceptions to the law. So it's not an absolute, but that was a law that Congress passed many years ago and is certainly relevant to the procedures that are going on today. So let's give a brief rundown of the posture of this case with a little bit more details. The facts of the case are thus. The Mexican government sued several U.S. gun manufacturers in federal court, alleging their practices facilitated illegal gun trafficking to Mexican drug cartels, causing harm to Mexico. The defendants moved to dismiss, arguing the lawsuit was barred by the Protection of Lawful Commerce in Arms Act, which prohibits certain lawsuits against gun manufacturers, as I just said. The district court dismissed the case, holding that the PLCAA applied and barred Mexico's claims. Mexico appeals. The U.S. Court of Appeals for the First Circuit reversed, holding that while the PLCAA does apply to lawsuits by foreign governments for harm suffered abroad, Mexico's lawsuit falls within the statute's predicate exception for claims alleging knowing violations of laws applicable to gun sales, which is another violation, which is another thing. So if it's the protection of lawful commerce in arms. So if you're selling your guns illegally, then you don't get protection because you're not doing it through legal channels. So, there's that. So, okay, that makes sense. The court found Mexico adequately alleged defendants aided and abetted illegal gun trafficking in violation of U.S. law, and its proximity caused harm to Mexico. The court rejected defendants' argument that the causal chain is too attenuated, which gets into the issue of proximate cause, right? So you have the issue of how far down the chain can someone be held responsible for what you do, right? So it's sort of the Rube Goldberg, right? At some point we have to draw a line. The cat bit the dog, which bit the snake, which bit your ankle, and so forth and so on. It's like at some point we just got to draw a line and say it's too attenuated. Proximate cause, big issue in law. Big issue in law. It's an issue in criminal law. It doesn't really pop up as much, but still an issue, right? So you have actual cause, basically but-for causation, that because this happened, that's actual cause. But then you still get into the issue of proximate cause, which is at some point we have to stop caring, or, the whole world will end. Because, everything will continue forever. There's got to be an end to it, right? So anyways, the court rejected defendants' argument that the causal chain was too attenuated, finding Mexico plausibly alleged direct harm from having to combat the well-armed cartels. The court remanded the case for further proceedings, allowing Mexico's lawsuit to continue. Thus, the question: can U.S. gun manufacturers be held liable for violence in Mexico under theories of proximate causation and aiding and abetting based on domestic production and sale of firearms that are later trafficked to Mexico cartels? That sounds like an interesting issue. I'm here for that. So we're going to listen to this and try to assess as we go, as we do. So let's go ahead and get started with this.
We'll hear argument this morning in Case 23-1141, Smith & Wesson Brands versus Estados Unidos Mexicanos. Mr. Francisco.
Mr. Chief Justice, and may it please the Court. Mexico asserts that American firearms companies are responsible for cartel violence ravaging Mexico. Its theory is that federally licensed manufacturers sell firearms to licensed distributors, who sell to licensed retailers, a small percentage of whom sell to straw purchasers, some of whom transfer to smugglers, who then smuggle them into Mexico, hand them over to cartels, who in turn use them to commit murder and mayhem, all of which requires the government of Mexico to spend money.
Yeah, so like for my money, if we're trying to get to Smith & Wesson, right, I don't want to know what does Smith & Wesson do wrong. So if this is correct, if Smith & Wesson sold it to licensed retailers, right, then Smith & Wesson did the lawful thing. Unless they had actual knowledge, that the gun dealers were then, doing the straw purchases, not just in some generalized sense, but they had actual knowledge with respect to particular sales, right? Or they conspired, or they aided and abetted that, then I would say there's no liability. It's like, yes, I mean, they might know in a sort of very vague sense that some people might sell guns illegally, but unless they know who those people are, what can they do about it, right? People do unlawful things with products all the time. Manufacturers know that people do unlawful things, but unless they have some knowledge of a particular sale or particular thing, what are they supposed to do about it, right? So if Smith & Wesson sold to a licensed retailer without particular knowledge that retailer was, doing unlawful sales, without aiding and abetting, without conspiracy, without something else, I'd be like, yeah, there's no liability there, because Smith & Wesson basically did everything they could. Now, maybe the gun store is liable, go sue them, but you can't get all the way back to Smith & Wesson. That makes sense to me.
Needless to say, no case in American history supports that theory, and it's squarely foreclosed by the Protection of Lawful Commerce in Arms Act. As to proximate cause, this court has repeatedly said there must be a direct relationship between the defendant's conduct and the plaintiff's injury. But no such relationship exists if plaintiff's injury is caused by multiple intervening independent crimes committed by foreign criminals on foreign soil to inflict harm on a foreign sovereign. As to aiding and abetting, Mexico doesn't identify a specific crime, criminal, or criminal enterprise that defendants supposedly helped.
Yeah, that kind of shoots aiding and abetting right in the foot, right? How do you aid and abet a crime if you won't tell me which crime? That seems like a fatal problem to a claim.
Instead, it asserts that defendants are liable for every illegal sale by every retailer in America because they know that a small percentage of firearms are sold illegally and don't do more to stop it.
Yeah, first of all, like, even what could they do in theory to stop it? Like, what can Smith & Wesson even do hypothetically? I don't even know in this situation, what could they even do? And yeah, this is like saying that car manufacturers know that a small number of cars will be driven illegally and they don't do more to stop it. Like what? Like, what are they supposed to do? Some people will drunk drive. Some people will even intentionally use a car as a weapon, and drive into people with intent, which may or may not be the true case in Karen Reed, lol, for example. But, it's like, what was Lexus supposed to do about Karen Reed exactly, right? Like, assuming Karen Reed did it, what was Lexus supposed to do exactly? You know what I'm saying? It doesn't make sense.
Again, no case in history supports that theory. Indeed, if Mexico is right, then every law enforcement organization in America has missed the largest criminal conspiracy in history operating right under their nose, and Budweiser is liable for every accident caused by underage drinkers, since it knows that teenagers will buy beer, drive drunk, and crash.
Facts. Yeah, like, why doesn't this work for Budweiser? Why doesn't this work for Lexus? Right. It doesn't make any sense. What are they supposed to do exactly? Can you tell us? Yeah, it doesn't make sense.
The First Circuit gravely erred in embracing that implausible theory and should be reversed. I welcome your questions.
Mr. Francisco, as to the predicate exception, which federal or state law is petitioner reputed to have violated?
So my understanding, Your Honor, is that they're invoking the federal aiding and abetting statute to argue that we have aided and abetted the federal statutes that govern the sale of firearms, and they're alleging that retailers have knowingly sold firearms to straw purchasers and that we aided and abetting that knowing sale. That actually raises a very important question about their allegation of knowing. I don't think it's relevant because I'm willing to even assume a certain level of knowledge. I don't think it matters. But their theory of knowledge is that we actually know that retailers are selling illegally. I'd actually urge you to look at that 2010 Washington Post article that they incorporate into their complaint. That article talks about a particular retailer called Lone Wolf. In 2010, it was the #1 seller of firearms that were found in Mexican crime gun scenes. And in that article, you actually have a quote from ATF that says that ATF has no basis to believe that Lone Wolf is doing anything illegal or wrong. Well, if the government doesn't know, how are we supposed to know? It reflects this convoluted theory that simply because the gun is found in Mexico can be traced back to a retailer. That means the retailer necessarily sold it illegally, and that we know that the retailer sold it illegally.
Yeah, that doesn't work either. That also doesn't work. Yeah, just because the gun wound up in Mexico doesn't mean the retailer sold it illegally either. Right? You can't assume that. And maybe they sold it completely lawfully. And then, the gun got transferred after that. Perhaps illegally, perhaps not. I don't even know, I don't know the finer points of such transfers. I don't know every law, but, until you actually tell me the law, just because it wound up in Mexico, I don't know inherently means that anyone broke the law. Maybe no one broke the law in order to get it to Mexico. I don't know for sure. Maybe that's possible, but it's you got to show someone did something illegally, and you can't just assume it. That doesn't make any sense. I need some steps in the middle, man.
Would this be a different case if there was a specific federal or state statute that you were known to have violated?
Your Honor, it would be a different case. I would want to know more because I still think that depending on what they alleged, I would have very strong arguments on proximate cause and aiding and abetting liability, but it would certainly be a different case.
Well, the reason I ask is because the exception is for knowingly violating a state or federal statute, and it would seem helpful in determining aiding and abetting, and then eventually proximate cause if that comes up, if you knew which statute we were dealing with.
So the complaint is a little bit vague on this. To the extent I understand it, they're looking at federal statutes that restrict the knowing sale of firearms to people who aren't authorized to purchase them. And then they're invoking the criminal federal aiding and abetting statute to claim that we're then liable for those illegal sales. I'm willing to assume for the sake of argument that that's valid because I don't think they come anywhere close to establishing aiding and abetting liability. And even if they did, I don't think they come anywhere close to establishing proximate cause.
I'm sorry, counsel, but exactly what role, I had difficulty telling from your brief, does foreseeability play in your proximate cause analysis?
So as this court has made clear in a number of cases, it's not that foreseeability is irrelevant. It's that foreseeability alone is not the standard. So it's necessary but not sufficient.
Yeah, very good point, right? So when you're talking about proximate cause and how far down the chain, it has to be foreseeable in some sense because I have to be in a position to prevent the harm. At least in principle, right? It's you want to impose liability on me for what I'm doing. Well, the harm has to be foreseeable in some sense because if it's not foreseeable, what can I do? Right? Because how am I supposed to prevent something I can't possibly foresee? That's not fair, right? It's if you want to impose liability on me, the damage has to be foreseeable. Now, he points out quite correctly that foreseeability while required, isn't sufficient. So even though I can foresee it, doesn't necessarily alone mean I'm liable. Because again, we get down to the Rube Goldberg, right? It's like, even if I can foresee down the chain, 8 steps or 10 steps, even if I can do that, at some point the law is going to be like, we just have to stop caring. We just have to stop caring, man. It's like, we can't just keep doing this forever. It can't be, the fly bit the spider and the cat bit the fly and the dog bit the cat. We just got to stop, man. We got to stop. So it's necessary, but not sufficient, 100%. But it's like at a bare minimum, I got to be able to foresee it if you want to try to impose liability. Otherwise, it doesn't make any sense.
There has to be a direct relationship between the defendant's conduct and the plaintiff's injury. And, Your Honor, I think that the plurality opinion you authored in the Hemi Group is directly on point. That is where a case where the plurality held that the city of New York couldn't sue a cigarette retailer for not filing the tax reports in order for the city to recover its lost tax revenue, because in between the city's injury of lost tax revenue and the retailer's failure to file the reports stood the citizens of New York who illegally failed to pay their taxes, and that broke the chain. This is a much easier case. Here we don't have just one intervening independent crime. We have a multitude of intervening independent crimes. So even if they could establish aiding and abetting liability, and I don't think they come even close under Twitter, they couldn't establish proximate cause, which is the other.
Twitter here, by the way, is of course a name of a case dealing with this issue as it related to liability under a different statute. So, yeah.
Other requirement here.
Counselor, it seems to me that the cases are a mess on proximate cause. And you're asking us in this case to choose among a variety of different explanations of it. I think, however, I try to break this down. I think their complaint is saying that the violation is selling to straw purchasers. And I think the risk in selling to a straw purchaser, and that's the known risk of that violation, is that that straw purchaser is giving or selling the gun to someone who can't possess it, because the likelihood is that they're going to use that gun illegally. And that's the risk of the violation. And I think that that's what their complaint says, which is, now, I'm going to put aside the lack of the conclusory allegations, and I agree with your point that they don't really tell us which dealers are doing this, who they're aiding and abetting. There may be a lot of conclusory allegations, but the theory, I think, that they're advocating is, if you're selling to a straw purchaser, that's, that the risk is that they're giving it or selling it to people who are going to commit crimes. Here, the Mexican cartel. So I don't know if this is a proximate cause case, or it really is what you say it's not, or that the allegations are insufficient for aiding and abetting. I think for us to go into proximate cause opens up a Pandora's box.
So I want to take one step back, Your Honor, because they're not alleging that my clients engaged in any illegal retail sale. None of my clients actually sell to consumers.
No, the complaint says they aided and abetted. Justice Thomas asks you, what violation? I believe the violation they claim is that the dealers are selling to straw buyers.
Yeah, but under aiding and abetting, I have to know they're doing that, or it's not aiding and abetting, right? I mean, stupid example. There's a taxi driver shows up to a bank. Three guys walk out of the bank carrying bags. They walk out calmly. The taxi driver takes them away from the bank to go to where they're going. Later, it turns out, of course, that they were bank robbers. But the taxi driver didn't know that, right? He just showed up to the bank to pick up his fare. He was called, presumably in this hypothetical. He shows up. 3 people walk out of the bank, with bags. He takes them on their way. You know, there's no one running, there's no one yelling, there's no one screaming, there's no alarm going off. So like, how was this taxi driver supposed to know that he was facilitating a bank robbery? He has no idea. So you can't get liability to him unless you can show somehow he knew, right? Unless you can show he knew, it doesn't get to aiding and abetting. You have to knowingly facilitate. So yeah, how did Smith and Wesson knew? And if your idea is that, well, they knew in some sort of very generalized sense, you're back to the same problem. You're even back to the same problem with the taxi cab driver. People sometimes rob banks, not as much these days, but still, people sometimes rob the bank. So I suppose there's some non-zero probability that for every fare, you're picking up a bank robber or whatever. It's like, unless you can get to something more specific, that vague knowledge doesn't get you anywhere. It doesn't help you.
Sure. And I just wanted to be clear that I think that the chain of causation, I think it's relevant both to proximate cause and aiding and abetting. I think that the chain of causation under the statute doesn't start at the illegal sale because we aren't alleged to have engaged in an illegal sale. It starts with the conduct that they allege constitutes aiding and abetting the illegal sale, which is the way that we manufacture and distribute our firearms. But I also think that's relevant to aiding and abetting liability because we're not alleged to have aided and abetted any cartels or any illegal purchaser. We're alleged, in this case at least as they presented it here, to have aided and abetted the retailers. And so they have to carry the argument that somehow we're liable for every illegal retail sale in America because we know that some small percentage of retailers may sell the firearms illegally and don't do more.
Yeah, that doesn't make any sense. If that's their theory, it doesn't make any sense. It's like that doesn't make any sense for Mexico. You're aware that some illegal sales may be occurring, I guess, but like, what am I supposed to do about it? What am I supposed to do about it? Even in principle, what steps can I take? I don't know.
Now I dispute
now, Mr.
that.
Francisco, I just want to pause there for a second. Sorry to interrupt you, but just to follow up on Justice Sotomayor's question, put aside aiding and abetting. Assume for the moment that you did aid and abet the sales. Your clients aided and abetted the sale of guns to bad apple dealers, ones they knew or intended to even for them to sell on to people in Mexico doing bad things. They knew that. They knew all of that. How would you not have proximate cause in that hypothetical?
So sure, Your Honor, and that is a huge assumption. But even accepting that assumption, for the same reason there was no proximate cause in Hemi Group. Even if you assume that we're on the hook for that illegal retail sale, you still have a multitude of independent crimes in between that sale and injury to Mexico. You have the straw purchaser that gives it to the actual purchaser. You have a smuggle across an international border.
I understand, but my hypothetical assumes that you know all that. Your clients know all of that, maybe even intend it. Now, whether there are allegations of this complaint sufficient, put that aside. But if you know or intend all of that, then what?
I still don't think that establishes proximate cause when you have an intervening independent crime. And I'll point you to Hemi Group, Your Honor.
Oh, yeah.
In Hemi Group, the underlying statute was the filing of the tax reports. The entire purpose of the tax reports was to allow governmental entities to collect tax revenue from cigarette sales online that weren't otherwise subject to sales taxes. But the plurality held that that independent intervening act still broke proximate cause. I think it goes back to the court's 1876 decision in the St. Paul Railway case, where you made clear that if there is a sufficient and independent
Wasn't
cause.
me.
Your Honor, I think of the court as a collective body that operates across time. And it made clear.
Gorsuch doesn't believe that.
Yeah, I do.
And it made quite clear way back in 1876 when you do have that, and I'm quoting, a sufficient and independent cause operating between the wrong and the injury, that does break the chain of causation, even if it's eminently foreseeable. Just like many, many, many years later in the Hemi Group case, the court concluded the same, even though it was eminently foreseeable that the retailer's failure to file the tax reports could lead to lost tax revenue.
Mr. Francisco, can I just put a point on this, because I want to make sure I understand the line of questions you've been asked. So it seems to me, as Justice Thomas began, that when we're talking about the statute that was the violation at the beginning for the predicate, it has to be a statute that was specifically applicable to the sale or marketing of the product, the gun.
Yes.
Justice Sotomayor asked you, so that's the retailer selling it to the bad guy, right?
Yes.
Okay. That's where the proximate cause inquiry comes in. Your client, the theory, right, the theory is that your client under example 2, has aided and abetted as the manufacturer. Proximate cause doesn't appear in that portion of the statute. It's only in the predicate portion. So if we accept that framing of the theory, the framing of the complaint, we're really only asking about proximate cause, as Justice Gorsuch was asking you, between the retailer, the sale, and the harm ultimately caused to Mexico. And then we're looking at the chain of events that you're talking at right now. Sale to the bad guy, smuggled across the border, misuse.
So I think I have two responses, Your Honor. The first is I actually disagree with how you framed it, but the second is even if I accept how you framed it, I still think there's no proximate cause. The statute says that there has to be proximate cause between our violation and Mexico's injury. Our violation is not the illegal sale itself. It's the actions that we undertake to aid and abet it, the violative aiding and abetting conduct.
How does that fit in the statute?
Yeah, I don't know that I buy that distinction. Our violation is not the illegal sales, the actions we take to aid and abet it. Yeah, that distinction doesn't work for me. Usually aiding and abetting gets you pretty much the same thing as doing the thing itself, or it can in principle, right? You are an accessory now. That's aiding and abetting is an accessory. And quite often as an accessory, you are now liable just as much as the principal is, which is a pretty good reason not to be an accessory to crimes, incidentally. So I'm not sure that you want to slice that statute that way, and I'm not really sure that argument does you any favors. But, okay, I guess.
Statute, though.
Your Honor, because I think the statute says the statute requires that sets forth the exception where a seller has knowingly violated an applicable statute and the violation, referring to the seller's violation.
But it's not just applicable statute. It's statute applicable to the sale or marketing of the product. So that seems to me to refer to a specific statute relating to this manufacture, sale, distribution of guns, not the aiding and abetting statute.
Well, I think it's got to refer to our violation. It refers back to the seller's violation. And here the seller hasn't specifically, and this maybe goes to the confusion that Justice Thomas pointed out, but the seller's violation is not the actual retail sale. We're not retail sellers.
Right.
The seller's violation here is the aiding and abetting of that retail sale. And I presume what they are invoking is the federal aiding and abetting statute, and they're trying to combine that with the actual specific sale. So I think there are all kinds of problems with their theory.
I guess I don't get that, Mr. Francisco. I mean, aiding and abetting is a form of vicarious liability. Why wouldn't you just say the aiding and abetting violation is the violation that is aided and abetted, which here, as Justice Barrett said, is the retail sale, say the sale to a straw purchase.
Yep, that's right to my mind. It's vicarious liability, right? And that's standard. So aiding and abetting the violation is just doing the violation. Yeah, that's the same thing. That's typical in aiding and abetting law. Aiding and abetting is the same thing as doing the thing. Aiding and abetting the murder is the same thing as doing the murder. That's usually how the law treats that. Yeah, that's right.
Sir.
Sure, Your Honor. I think I'm just trying to construct the statute properly, and I think as a matter of proper statutory construction, that's where you begin the proximate cause with our violation. But I don't really want to fight about it.
But your violation, as a matter of vicarious liability, is the violation that the retail seller, sells to the straw purchaser.
Only if they know about it. That's where it goes too far. That's where it goes too far. So I'm vicariously liable if I aid and abet you. That's true. But if you commit the crime and I don't aid and abet you, I have no liability. So you can't get to vicarious liability just because I sold to the dealer, who then sold illegally. That doesn't make any sense, right? Then Budweiser would be liable, then Lexus would be liable, then anyone would be liable. That doesn't make any sense. You have to show that I aided and abetted to get to my liability, or I was in a conspiracy, or perhaps willfully blind, something. So that's a step too far.
Your Honor, I'm not sure that's right, but again, I'm willing to assume for the sake of argument that it is right, because I still think that there's no proximate cause in between between the illegal retail sale and Mexico's injury off in Mexico, and I sure don't think that they've come anywhere close to establishing aiding and abetting liability. I've already explained why I think there are multiple independent crimes after the retail sale, in addition to the smuggle across an international border and the murder and mayhem committed independently by cartels in Mexico. To me, that is more than sufficient to break that chain. But in any event, I think that their theory of aiding and abetting liability is equally far-fetched. I think this is—
So with reference to aiding and abetting, could you just explain to me the sort of structure of this industry? Who are these distributors? Are they pass-through entities? Are they completely independent? Might they be both? What's the—
They're independent entities.
$20 from Maya Razvidin. Thank you very much for the super chat. I'm sorry if you answered already, but what's the precedent here and what case law exists for this? If Mexico has leaders affiliated with cartels, can we sue for buying illegally to violate our laws? Drone purchases cars. Well, whether or not we can sue Mexico or not, let's just stick to this issue, right? So let's just stick to the broadest possible principle. And let's just like kind of go back to black letter law, because we can kind of do this in black letter law to some degree without like worrying about the specifics, right? So the precedent sort of is the black letter law, which is, you know, if I cause injury to you, I have to be I'm responsible for that injury. Right. That's sort of the black letter principles. Like I caused injury, I get to pay for the injury. Right. Now, if I didn't cause the injury directly, but I knowingly facilitated it, then also I might be responsible because I knowingly facilitated it. Right. So that kind of thing. And then we talk about this idea of proximate cause as well, which is this idea that even if I facilitated it, like at some point, right, we gotta draw a line and say, well, we're just gonna stop caring at some point down the line. And where exactly that is a little fuzzy, but you know, at some point we gotta stop caring. So like the underlying principles that Mexico seems to be trying to use is black letter law. It's actually just black letter common law. So, you know, it's solid law, but what they're trying to do doesn't work for the same reason, right? That's what they're trying to do. It's like, okay, it's like you have liability. All right. Why? Did I cause you injury? Well, no, you sold to a guy who blah, 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 who caused me injury. Okay. Did I violate the law in selling to the guy? Well, you had some vague knowledge that some guys you sold to might blah, blah, blah. It's like, no, that doesn't work, because that's not specific enough for me to try to do anything about. And if it were, again, Budweiser would be responsible, Lexus would be responsible, and so forth and so on. Plus, of course, also in this context, there's also the Protecting and Lawful Commerce Act. But I don't really think that really fundamentally does anything here, because in some sense, the Protecting Lawful Commerce and Arms Act really was just trying to reset the common law, because people were trying to go after the gun dealers for selling guns because they worked. It's like that doesn't make sense. It's like going after Budweiser because their product worked, or going after Lexus because their product worked, even if it caused injury. So in some senses, the PLCAA was just trying to reset the common law and trying to avoid like the more creative interpretations that they were trying to do. So the PLCAA doesn't really, I mean, they'll probably cite it at some point, I'm sure, but in some senses, it doesn't really factor into this equation because it just doesn't work under sort of basic common law principles. So I sort of hope that answers your question, and I do appreciate your super chat. Thank you.
Your Honor, it's possible that there might be some internal distribution, but by and large, a manufacturer makes the firearms. Then there are distributors who purchase the firearms from different manufacturers. Those distributors then sell firearms to retailers. Everyone in this chain is fully licensed. The retailers then are fully licensed, and they sell to purchasers. The allegation is some...
Do I think we should entertain it? I don't know what you mean by entertain it. I don't know what you mean. I don't think the theory works. I don't think their theory of liability works. I don't think it's legally sound. So, but I already said that. So I'm not sure what your question is, because I thought I already said, like, I don't think it works under basic common law principles. I don't think it works because it doesn't make sense. So I don't know what you mean by, do you think we should entertain it? Because that feels like the question I already answered. So I don't understand what you're asking me. I don't think there's liability, if that's what you mean. Based on Mexico's theory, it doesn't make sense to me.
Small percentage of those sales are illegal, and we know it.
Is your representation that the manufacturers really only deal with the distributors, or do you?
Was my opinion of the country, not you, take on such frivolous claims? I still don't understand the question. I'm trying to honor you because you gave me $20 in super chats, but I'm still not understanding the question. I think that Mexico could sue the same way anyone could sue if they had a theory that worked. I don't think the fact that it's Mexico suing it really changes the analysis, if that's what you mean. Not that I can see, not in the case we're talking about. So the fact that Mexico is suing doesn't change anything. It's just the fact that their theory doesn't work legally. So that's what I think. So hopefully that answers your question.
You understand the manufacturers to be looking at and paying attention to the dealers too?
Well, Your Honor, we're here on the complaint, and as far as the complaint alleges, it's simply the manufacturers going to the distributors going to the retailers.
Right, I'm asking from what you know of the industry and your client.
I think they're saying, how is it not thrown out? Well, it was by the district court. The district court did throw it out. The Court of Appeals revived it because apparently they thought it made sense. Why? I don't know. I'd have to read the Court of Appeals to see why they thought it made sense, but it doesn't make sense to me based on the description that's being said. But the district court threw it out. The Court of Appeals brought it back for some reason that is unclear, but that's why we're here. So, yeah.
Is the manufacturer essentially dealing with the dealers, or is there like a big roadblock?
All right, so
which is in the form of the distributors?
We're outside of the complaint now, so I want to be very careful because I don't 100% know the answer to all of your question, but my understanding is that the manufacturers are not generally dealing with the retailers. You do have this tiered distribution chain where they're principally dealing with the distributors to the retailers, and so on. I think that the reason this is such an implausible aiding and abetting theory is because I actually think this case is a lot easier than the Twitter case in a number of different respects. First of all, Twitter, you actually had a specific criminal, ISIS. You had a specific crime, the Reina nightclub attack, and the defendants were actually providing that product to that criminal. You don't have any of that here. Instead, their theory is that by simply knowing that some percentage of retailers may be doing something illegal, that somehow puts us on the hook for everything that the retailers are doing. This is kind of a common law area. You'd think that they could cite one case that comes anywhere close to that, but they don't cite a single case.
Mr. Francis.
Yeah, I mean, that's what I was saying in response to the question earlier. It's like, that's what I was saying earlier. For me, it's like, this is common law principles. And it's like, it doesn't work. It doesn't work under common law because it's like, it doesn't make sense. Yeah.
That's sort of what I'm a little confused about, and I wanted to focus on, which is, it seems to me that the core of your argument, both here and in your brief, has been that there's an implausible theory of aiding and abetting liability based on what they've alleged, and no case in American history supports this theory of liability, as if the question before us is evaluating the viability of Mexico's theory.
I feel like in large part, the question to some degree is asking you to evaluate the viability of Mexico's theory. Isn't that part of exactly what we're doing right now? Okay.
And what I'm looking at is a statute that I think really makes this case about the scope of the predicate exception, that it's not really, an invitation to assess as a common law matter whether or not we think these facts allege aiding and abetting liability. Would you agree with me?
I don't understand this argument. The predicate exception basically in so many words says you don't get protection if you broke the law. We could go to the exact wording of it, but I don't think this hinges on the precise wording of it. So I'm going to keep it more general because I don't think I need to be more precise. So why should I if I don't need to be? Right? So basically it says you don't have liability unless you broke the law. So the predicate exception only applies if they broke the law, which at least in part relates to if we're under aiding and abetting theory, is there sufficient evidence to make that argument? So again, it kind of feels like that's part of what we're doing here. Justice Jackson and I seem to have a very different understanding of the assignment right now. So I'm a little bit confused.
That the PLCAA statute takes off the table theories of tort with respect to these kinds of manufacturers, and really the only question is whether the statutory exception applies in this situation.
Well, I think I would agree that we're arguing about what the meaning of the statute is, but the statute can only be triggered if they find a violation that's the proximate cause. Here, the violation that they've identified as aiding and abetting.
I understand, but that proximate cause analysis is coming up in the context of an exception to the immunity that Congress has set forth. Is that right?
Sure, yeah.
And I think that's important because the scope of that exception may not be coterminous with our understanding of aiding and abetting liability as a common law principle.
I suppose that's hypothetically possible, but if that's possible, it would only be possible because of the exact wording of the statute. So I suppose it's possible the statute has to some degree abrogated the common law in some way that would be material. But if that's true, then it's true because of some exact wording of the statute. And she hasn't said, she hasn't said, according to subsection, A to B, what it actually says is this. You're talking about the common law. The common law is not applied. What matters is what A to B says. And she's not saying that. She's just saying the statute matters more than the common law. I'm like, well, I guess that's kind of true, but what part of the statute do you think changes the common law in a way that is material here? And she's not saying that. So her response confuses me. I'm confused.
In other words, you look at Twitter, for example, and you say, okay, is what is being alleged here the same as aiding and abetting liability as it was set forth in that statute? That was a totally different statutory scheme. That statute, JASTA, in the Twitter case, was about allowing for these kinds of claims. And so what counts for aiding and abetting liability in Twitter may not be what Congress intended for this exception. I feel like we have to focus on where we actually are in this context in making this determination.
Well, Your Honor, I think that's where I might very much disagree with the theory that you're articulating. I think that they do have to show a violation. They've alleged it's aiding and abetting. There's no aiding and abetting in the air. What Twitter purported to do was look at traditional aiding and abetting principles.
Well, I understand, but Twitter was a different kind of statute. We have said that, when we're doing statutory interpretation, when we're thinking about aiding and abetting liability, it may not be the same in every statutory scheme. And
again, I suppose that's possible to some degree, although in that situation, you would imagine the statute itself would provide for in what way you're modifying aiding and abetting liability, because aiding and abetting liability is a well understood principle. So it's like black letter, right? It's basic principles. It's black letter law. So it's like, can a statute modify that? Sure. I mean, why not? I suppose to some degree. I mean, I don't know if it can necessarily do it infinitely, but at least to some degree it's possible. But you would presume that if you're going to modify the aiding and abetting liability, you would do it in a way that shows that in the statute so you understand that you're doing it, or it'd be otherwise clear implicitly from context or something else. And again, she's not citing the statute. She's not saying, well, this isn't standard aiding and abetting liability, because if you look at this phrase of the statute, it's contemplating something else. She's just saying it in a very general way. She's like basically saying it's possible this statute doesn't do standard aiding and abetting. I'm like, well, I suppose it's possible, but can you tell me why? And if it doesn't say it, then can you tell me why we wouldn't just assume that Congress was just using the default rule because the default rule is understood? Why would we go out of our way, or why would we do that? Why would we do something differently here? Why exactly would we do something differently here? I don't quite understand. So I'm confused.
I guess what I'm just trying to, I mean, this is not supposed to be like a statement that is necessarily against your position. I'm just trying to understand the framing of this. It seems to me this is a statutory interpretation question about the meaning of what the predicate exception says, knowingly violated a state or federal statute. Aiding and abetting is in the examples. It's not even in the actual core statutory statement of what would qualify. So shouldn't we be focused more on trying to understand what Congress meant when it was accepting, you say narrowly, a certain kind of claim?
I mean, I guess, again, like, I suppose, but why would we interpret it differently unless there was a reason to? And she's not saying. It's like, should we focus on the statute? I'm like, I guess, but to what end? I don't understand exactly. I don't get it.
Well, Your Honor, to the extent I understand what you're getting at, first, I do think that you really do have to grapple with the aiding and abetting liability issue, and Twitter sets out the framework. But even if you want to take a step back and look at what Congress was getting at more broadly, Congress's entire purpose was to prohibit lawsuits just like this one. It was trying to prohibit lawsuits that had been brought by the city of Chicago, the city of Cincinnati, the city of Boston on theories and seeking relief exactly like this one. So if you adopt my friend's position on the other side, you have essentially gutted PLCAA. And remember what the larger purpose of PLCAA was. It was actually to ultimately protect Second Amendment rights by preventing plaintiffs from.
Yeah, that's true also. And you know, Ketanji Brown Jackson doesn't like that answer. It's like, okay, well, if you want to, focus on the statute, then the purpose of the statute was basically to prevent frivolous lawsuits against gun manufacturers. So it's like, so focusing on the statute only helps us because the broader purpose was to stop these lawsuits that basically were amounting to gun killed person, therefore gun dangerous, therefore manufacturer liable. It's like, no. The gun did exactly what it was supposed to do. The gun didn't malfunction. The gun didn't fail to operate. The gun didn't, blow up in someone's hand. The gun didn't misfire. The bullet didn't magically somehow, deform or whatever. None of those things, right? The gun actually worked the way it was supposed to. So it's like, no, you can't do that. And so if you look to the broader purpose, it only protects us. And she doesn't like that answer. Caddy Corner for $10 gives just a super chat, and I will give you a heart back. I appreciate that. Yeah.
Bankrupting the industry through frivolous lawsuits. After all, the Second Amendment doesn't really mean anything if there's nobody from whom you can buy a firearm. So I'm willing to take.
Just to follow up on this, PLCAA, as you call it, says that you've got to show a violation of a state or federal statute. And Justice Thomas asked you, and I'm still not sure we've completely identified what that statute is. I think it's 18 U.S.C. 922, maybe 923. You agree with that?
Your Honor,
We don't know. Okay.
I don't think the complaint was clear on it. We did
That's what they
speculate about
cited
that.
in-
We speculated about it in our brief. I think that might be the statute.
And then trading and
cited.
abetting would be 18 U.S.C. Section 2, I
I
think.
think that's right, yeah.
Okay. All right. I just want to be clear on what is being alleged. And then your friends on the other side make a good point about our precedent in direct sales, which I did not write either and is about 80 years old, too. I want to give you an opportunity to respond to that.
Sure. I will agree with them on one point, that direct sales is their single best case, and direct sales isn't even close. In direct sales, you had a manufacturer that was selling to a specific doctor in such massive quantities that there was no possible lawful explanation, and in addition, the manufacturer then further encouraged that doctor to buy more by offering it massive discounts on bulk purchases. So to use the language of Twitter, you had both a very high degree of scienter and a very high degree of conduct and encouragement.
Well,
nothing like that here.
That raises another question I had, and then I'll stop. But in terms of aiding and abetting under Section 2 for 922, if that's what we're talking about, those are criminal statutes. And Rosemond says that aiding and abetting in the criminal arena generally requires intent, not knowledge. But you didn't make anything of that.
Well, Your Honor, I think that because they don't come anywhere close on any standard, whether you call it knowledge, whether you call it intent. Remember, in Rosemond, the defendant was actually part of the drug transaction. The question was, did Rosemond, in participating in that drug transaction, also know that one of his collaborators was going to shoot somebody? You don't have anything like that here. The other respect in which this is far different from Twitter, in a way that also highlights direct sales, is that in Twitter, the defendants there were far more active. We were here just a few weeks ago talking.
Big Rig 0485 for $20 says, could the Supreme Court decide whether they'd even hear the case or not? Sure. Yeah, it's discretionary review. They didn't have to hear this case. The case seems ridiculous on its face. The kinds of cases the Supreme Court agrees to hear over the years puzzles me. Hearing this, but not a state suing another state. Well, in that situation, they said that the state didn't have standing because the state wasn't harmed by the injury. And standing is a fundamental requirement in order to bring a suit. So they threw out the lawsuit because of standing issues. And so it's like, but that's required in order to bring a lawsuit, generally speaking. And this lawsuit is discretionary review. So they don't have to hear it in the first instance, and they want to hear it not for at least the reasons that they and I also think that the court below got it fundamentally wrong. So how does Mexico have standing? Like, in theory, how do they have standing? Well, because they've been injured by bad things happening. They've suffered an injury, but they've suffered an injury that is cognizable and to which a court could theoretically grant remedy. So, yeah, I mean, they seem to have standing, but their theory doesn't really work because you can't show the underlying liability for the person. What would be a good example? It would be like saying, what would be a good example? I'm hard pressed to come up with one off the top of my head. Okay, here's one that sort of works, maybe. No, because even then it's too direct. Yeah, I'm having a difficult time coming up with a sufficient analogy to make it make sense because of how indirect this is. It would be like, okay, maybe it would be like if I got into an auto accident and the airbag didn't go off. All right. So my injury is the airbag didn't go off. That caused me harm. I'm suing you. So I have a direct injury that occurred to me that caused me harm that the court could do something about. So that would be standing. But then I want to sue the car manufacturer, and I want to sue the airbag manufacturer, and I also want to sue the distributor. And it turns out that there's nothing wrong with the product, so product liability doesn't work. It's just that when it was installed in the car, they didn't install it right. Okay. And so it'd be like me suing and saying, okay, airbag manufacturer, you're responsible because this didn't go off. And that was a harm that occurred to me. And the airbag manufacturer says, well, no, it's not it's not exactly that the airbag didn't go off. There was nothing wrong with the airbag. The airbag works perfectly fine. The problem is the manufacturer, when they installed it, put it in wrong. And so that's the liability. So I have standing to sue the airbag manufacturer. It's simply that they have no liability because they didn't fundamentally do something wrong. So I don't know if that makes any sense, but that was the best I could do off the top of my head. So hopefully that made some sense somewhere along the line. And thank you for your super chat. It was thoughtful. Okay, let's go back to this.
About algorithms. The way that algorithms work is that they match up the creator's content with the user's interests. So it starts out with ISIS's vile content. It surveys the billions of users on the platform, figures out which ones are actually interested in that content, and puts the two together. We're not doing anything even like that. This is an a fortiori case after Twitter.
Counsel, the complaint says that 2% of the guns manufactured in the United States find their way into.
Lois says, except this is a product malfunction, it's people's actions. Guys, every analogy breaks down at some level. I said I was having a difficult time coming up with an analogy. I spent some time trying to craft one for some period of time to try to find something that seemed at least workable enough to explain the point. Please don't attack me because there's differences between it. I know there are different. You're right. There's a lot of differences, but I was trying to find an analogy that made that to illustrate the point, and trying to say, okay, it doesn't work because of this or doesn't work because of that is really discouraging, because I was trying to do my best to find something that works, and it's like, give me a break, man. Give me a break. Patricia Bradshaw for $20 gives a super chat. Thank you very much.
Mexico, and I know you dispute that, but is there a number where your legal analysis might have to be altered? If it's 10%, if it's 20%, at some point the proximate cause lines that you draw really can't bear the weight of the ultimate result.
So, Your Honor, I take their complaint as it comes. If we're talking about proximate cause, I don't think that the percentage would actually matter when you have a multitude of intervening independent crimes. In Hemi, for example, I don't think it would matter whether the city was losing, whether everybody was not paying their taxes in New York City or just a small percentage were not paying their taxes in New York City. What mattered is that you had the independent decision of the New York City taxpayers not to pay their taxes that broke that chain. Here you have a multitude of intervening independent crimes, so I don't think that percentage would matter at all on my.
Well, I mean, at some point it must matter. I mean, I understand you don't want your theory about the different steps, but if it ends up that most of your product or whatever number you want to get to a change in your view ends up there, you've got to know that, and if you know that, do you still have to go through the?
All right, I've come up with modifications for the car airbag example to hopefully get closer. Okay, so modify. I revise and extend the previous remarks as follows. Okay, so the airbag manufacturer says, as it turns out, the airbag didn't go off because what was in your car was a bag of sand. Okay? We sold an airbag to the manufacturer, and then some people decide to steal that airbag and sell it on the black market. And then in your car, instead of an airbag, what they put in was a bag of sand. So the bag of sand didn't go off because it's not an airbag due to the criminal conspiracy by some other people. Of course, we had no way of knowing that when we sold the airbag. We had no way of knowing that. We know that sometimes happens. We had no idea it would happen here, so we had no particular knowledge they were going to replace your airbag by a bag of sand. Also, we tracked down the airbag that was supposed to go into your car. We found it on the black market. And as it turns out, it would have worked properly had it been installed in your car, but that's not our fault because it was a bag of sand that didn't go off. Is that closer? Are we happy now? Great, moving on.
Intricate step by step, or can you just say this is what they make and pick whatever number you want? 70% of it ends up in Mexico.
I still think you do have to go through that analysis, Your Honor, but even if you disagree with me, I'm willing to accept the allegations in their complaint and the number of 2% and to be quite confident that that is not enough for proximate cause, particularly when their theory is that simply because a firearm was found in Mexico at a crime scene and can ultimately be traced back to a particular retailer that sold it in the first instance, that means that the retailer illegally sold it and that we knew the retailer illegally sold it. Even the ATF and the federal government rejects that theory.
Thank you. Justice Thomas?
Mr. Francisco, in direct sales, there was exactly that, a direct sale to a doctor. And the seller worked closely with the doctor to work around the limitations. In your brief, you summarized the chain that you've mentioned or alluded to a number of times. Would you just list the chain for our benefit?
Sure. Starts out with a licensed manufacturer, a manufacturer that the federal government says is allowed to make firearms. It then distributes its legal firearms to licensed distributors, distributors who the federal government says are allowed to distribute them. They then sell to licensed retailers, retailers that the federal government says are allowed to retail. Those retailers, some very small percentage of them, unknown number, but some small percentage of them, transfer those firearms illegally to straw purchasers. The straw purchaser then hands it over to the actual purchaser. You then have a smuggle across an international border. Yet
this feels like a lot of intervening steps, man. Right? It's like putting aside the fact that they didn't aid and abet in the first place, but like even if they had, right? It's a lot of steps. You know, the ankle bone connects to the leg bone connects to the hip bone connects to the chest bone. Yeah, it's a lot of steps, man. It's a lot of steps.
Another violation of law. The smuggler then presumably gives it to the cartels who are illegally possessing the firearm in Mexico under Mexican law, as my friends have described it. Then the Mexican cartels engage in murder and mayhem against the good people of Mexico, all of which in turn causes the Mexican government to have to spend money to respond to that murder and mayhem. With respect, there's not a single case in history that comes close to that. They don't even cite cases that find a manufacturer, I think, ever liable for the unlawful criminal misuse of its products, other than the cases that PLCAA was meant to prohibit, and perhaps other than the Avis case, the Florida Supreme Court case. But they certainly don't cite anything that comes close to that chain of causation, which is more extreme than the cases that PLCAA was meant to prohibit.
Justice Alito? Justice Sotomayor? Justice Kagan?
So suppose, Mr. Francisco, and this is not the complaint in this case, so I'm making changes to it. Suppose there's a manufacturer and it deals directly with a network of dealers, or there's a wholesaler and it deals directly with a number of dealers. I think one of the defendants in this case is a wholesaler. Either way, let's assume you...
$10 from Big Rig 0485. Based on what you've heard so far, do you have a prediction on the decision and where it goes? I know it might be too early. Yeah, they're going to rule in favor of Smith & Wesson. I'm pretty confident. Now, as to what the vote is going to be, I'm not 100% sure. Somehow I have my doubts it's going to be 9-0, although it really should be, to be quite honest. But, you know, Smith and Wesson's going to win. Given this, there's no way. Smith and Wesson's going to win, for sure. Probably some salty decision by Justice Jackson on guns bad, or I don't know what they're, whatever.
Have a manufacturer / wholesaler that deals directly with a network of dealers, and suppose that that manufacturer does have knowledge that a particular dealer does more than the usual share of straw transactions.
Okay, so like this is a little bit more interesting. So now we're in a hypothetical where a manufacturer has actual knowledge of a particular dealer that does more than like the normal. And so like that's a lot more interesting with respect to potential liability for that person. That makes a lot more sense in that hypothetical.
And also knows that more than the usual share of guns wind up in Mexico, and particularly at Mexican crime scenes. So that the manufacturer...
What is a straw seller as opposed to a straw buyer? I don't know what a straw seller would be. What would that be? A straw seller? I don't know. Do they require an FFL? If they're doing things legally, yeah, typically, unless they're in such small quantities that they don't need an FFL. I'm a concealed carry in New York State and must buy from an FFL. Where's the crime scene, so to speak? Your question confuses me on multiple levels. Thank you for your super chat. They're saying straw buyer. What is a straw buyer? Oh, that's a lot easier. A straw buyer is not the real buyer. A straw buyer is someone who's buying for somebody else. That's easy. A straw buyer is someone who's buying for somebody else. They're not really the buyer. That's what a straw buyer is. That's easy enough. Same sense as a straw man, in like a straw man argument where you substitute one for the other. Yeah, that's what a straw buyer is.
In the way that manufacturers do, I think, when they're dealing with dealer networks, they're paying attention to their dealers, and they're trying to figure out whether there's a dealer whose sales are kind of out of kilter.
The person who sold it would be a straw seller? Well, no, not necessarily, because they may not know that. So a straw buyer is someone other than the buyer who's buying. They're not really the buyer. But it's not the person who sold it didn't do anything wrong if they don't know that, where they don't have any weight of knowing that. And even if they did know that, I'm not sure that makes them a straw seller so much as they're aiding and abetting the straw buy. If we're going to try to like say that straw seller is a thing unto itself, then I don't know if that makes you a straw seller so much as you're aiding and abetting the straw buy. But okay. $5 from LSD Ale. Is there a feedback mechanism to let the manufacturer know what retailers are allowing straw purchases? And so why doesn't the government intervene? I don't know the answer to that question. Straw seller could be a fence. Well, I suppose a straw seller would, in this context, be someone other than the real seller. I suppose that would be a straw seller if we're using the terms consistently. So if a straw buyer is someone other than the real buyer, a straw seller would be someone other than the real seller. So it'd be someone who's pretending to be the seller but isn't really the seller. So I suppose that's what a straw seller would be. I guess, by logic. I'm not, yeah.
With the rest, and they think, yes, I have a dealer whose sales are out of kilter. They're doing more straw transactions. They keep on selling to people who are taking the guns to Mexico, and particularly to people who are leaving the guns at Mexican crime scenes. Is that enough?
Your Honor, that's obviously very different, as you acknowledged. Even in that case, if the manufacturer was simply treating all of the dealers the same, including that dealer, then I don't think you would have crossed the line into aiding and abetting
Treating them the
liability.
same. What does that mean?
So, like say they have a policy that says, look, I sell firearms. Any dealer that wants to purchase
a middleman? No, it would be worse than a middleman. A middleman you would typically know about. That doesn't make him a straw seller. So the straw seller would be someone that I don't know, right? Because I'm getting duped in the same way the buyer is duping on their end, right? They're pretending to be the buyer, but they're not really the buyer, right? So that's the problem. And so this would be a situation in which I'm buying from someone who I believe is the seller, but isn't really the seller. So actually, I suppose one example might be drop shippers. That might be an example, because in some situations, not necessarily all, some drop shippers are pretending to be the person that they're getting the goods from, but they're not the person they're getting the goods from. They're just pretending to be. They're pretending to be, whoever. They're pretending to be, pick your favorite company, Casio, because I'm doing watches recently. So they're pretending to be Casio. I think I'm buying from Casio. They're pretending to be Casio, but they're not really Casio. But they're getting drop shipments, right, from Casio, hopefully. So they're selling an authentic product, but they're not really the seller. Or maybe they're not selling an authentic problem and they're not really the seller. But I'm getting fooled into who the seller is. So that's what a straw seller, I suppose, would be. So maybe that's an example. Something like that. Big Rig 0485 says a collection of illegal sellers to cartels when it's really the U.S. government. Yeah, maybe. Yeah, maybe. If the U.S. government is really the one doing it, and they've put up a front or gotten people to act on their behalf in a way that's not being disclosed. Yeah, maybe. Good one. Yeah, maybe. Thank you for the super chat.
Firearms.
I see.
I'm going to sell them to
Okay,
that
well, they
dealer.
are treating them the same. I mean, from one perspective, that's the problem, that they're treating this rogue dealer the same as the good dealers, right? Even though that they know that the rogue dealer is in fact a rogue dealer. Isn't that enough of a problem?
All right, I'll give you another one for a straw seller. I'll give you another one for a straw seller. Every controlled buy or every sting basically by the cops ever. Hi, I'm a drug dealer. Would you like drugs? But I'm not really a drug dealer. I'm the police, but I'm not going to tell you that part. Hi, I'm a drug dealer. Would you like some drugs? I've got drugs. Would you like drugs? Drugs are fun. Drugs time. So there you go. There's a straw seller. Basically every controlled buy in the history of ever. We finally found a controlled seller. It was the government all along. Lol.
One thing that's not, that is the same, is that we're at a 12B6 stage.
Sure. And, Your Honor, I think I'd invoke Twitter, where the social media platforms knew to a metaphysical certainty that ISIS was on its platform doing nefarious things. And that knowledge to a metaphysical certainty wasn't enough if you were simply treating your customers all the same and you were indifferent to what they were doing. I think this case is a lot easier than Twitter.
Yeah, I guess that's the question. Is the case that I gave you, is it a Twitter or is it a direct sales? It seems to me more like a direct sales. I'm a manufacturer, I have a dealer network, I know that there's one dealer that's way off the beaten track and doing things that are really different.
Right.
That seems a direct sales.
And if I can explain why I think that direct sales is far more extreme than your hypothetical. Remember, in direct sales, it wasn't just that this doctor was purchasing so much that there was no possible explanation. There was no issue. Nobody even argued about whether the direct sales was treating everybody the same. But in addition, what that manufacturer was doing was explicitly encouraging that doctor, who it was knew was already illegally prescribing, to do it even more. There's an example in the facts, for example, where the doctor orders 2 batches of pills, one for 1,000 pills and another for 100 pills. And direct sales comes back and says, don't do that. I'm just going to cancel your 100 order because I'll sell you another 1,000 pills at this massive discount. So you not only had a high degree of knowledge, you had a very high degree of conduct with the manufacturer actually encouraging.
So you think that's
oversale.
necessary to direct sales, that there's a kind of encouragement in addition to a realization that your products are being used in this way for these purposes?
Yeah, I think that's the necessarily implication of Twitter, where you had knowledge to a metaphysical certainty that one of your customers was doing something bad. But what the opinion makes clear is that simple knowledge doesn't get you across the line unless you're, in addition, acting in an unusual ways.
How about if the conduct is like, and we do this for everybody, don't get me wrong, we do this for everybody, but it's particularly maybe important to Mexican gang members, is that we make it so that you can, easily scrape off serial numbers. And we construct a set of products that are obviously useful in their characteristics for cartel members.
Well, Your Honor, the more you ratchet up the facts and make them cartel-specific, I think the closer you do get to direct sales.
Those allegations are in this complaint, right? That the manufacturers have basically designed and manufactured a set of weapons with a set of characteristics that are peculiarly useful for criminal activity.
I'd like to know what that is. How are these guns peculiarly useful for criminal activity? Do I not know something about these particular guns? Is there a factual basis here for this statement? I mean, so like, okay, I sort of understood the example, right? I manufacture a gun where the serial number is particularly easy to get rid of. And so it's like, oh, okay. All right. So that sort of is a thing. Okay. And then she says these guns are particularly useful for criminal activity. In what way exactly are these guns peculiarly useful as opposed to other guns? What guns is she talking about? In what way are they peculiarly useful? I have follow-up questions. Okay.
And that's where I don't think you would be getting anywhere close. If we simply make our firearms in a way that the general public likes, and we allow whoever wants to buy our firearms, and we know, as in Twitter, that some percentage of them are going to do something wrong, that's not the type of affirmative action that gives rise to aiding and abetting liability. After all, the social media platforms and Twitter did know that ISIS was on their platform. They were much more active than we are in the ways that I've already described. This court said as a matter of law on a motion to dismiss that that wasn't even close enough because there was no unusual treatment of ISIS relative to any other customer.
Thank you.
And there was no affirmative conduct towards ISIS.
Justice Gorsuch.
Just one question. Is there any reason for us to reach the proximate cause question if we conclude for aiding and abetting that you win?
If you rule for us on aiding and
You guys are killing me. You guys are killing me in chat. You guys are killing me right now in chat. You're like, don't you know removing serial numbers is illegal? Yeah, it's like, what a way to miss the point. And then we have this chat says, oh, don't you know that you can't make the serial number easily removable? There's super specific guidelines. Once again, way to miss the point. Way to miss the point. What if they did, though? You guys are killing me right now. You are killing me. Oh, man. All right.
Betting that will completely dispose of the case. The reason to also address proximate cause is because it's an extraordinarily important issue that I think applies in many different contexts, which is why there's such a broad range of amici in this case that go well beyond the firearms industry.
Obviously, the serial numbers weren't removed. Okay, do you understand what a hypothetical is? It was a hypothetical. Do you understand what a hypothetical is? Well, these serial numbers weren't removed. Do you know what a hypothetical is? You're killing me. I'm dying inside. Watch my soul slowly leave my body. It is leaving. It is leaving.
So while you could completely resolve it on aiding and abetting, I would urge you to address proximate cause as well.
Justice Jackson?
So, Mr. Francisco, I'm just trying to understand what you mean by resolve it on aiding and abetting liability. Don't we have to have a conception of aiding and abetting liability that is specific to this statute? You seem to be drawing on others, and I thought we took a statute-by-statute approach to aiding and abetting liability. We've held as much. We've said that before.
Well, Your Honor, in Twitter, you were applying aiding and abetting principles that arose in the context of a murder when you were talking about social media platforms. I think the whole point of Twitter was that there is a set of general aiding and abetting principles.
Oh, yeah, that definitely makes sense. Oh, that's great in chat. C. Adam Scott says, hypothetical is dumb. If the manufacturer makes it easy, even though they can't. Oh, yeah. Yeah, that definitely means that they won't. Yeah, you're wow. That's just truly amazing. That is truly amazing. Don't you know that there's a law that says the serial numbers has to be manufactured a particular way? Don't you know that that means that they can't do it? Oh, okay. Oh, that means that no manufacturer will. Oh, because it's illegal. Oh, that's nice. It's nice that we pass a law and it magically means it doesn't happen. Because we passed a law, don't you know? Don't you know that no manufacturer can do that? It's illegal.
Principles, and that is the law that informs what aiding and abetting liability. I don't even know how you would do this kind of statute-specific aiding and abetting liability outside of the general principles.
Well, I thought we were only looking at aiding.
Are you not getting the points, or are you just trying to irritate me and derail chat? I don't know which one is happening right now. It's beginning to irritate me. I can't continue to go down these rabbit holes because you guys are slowly killing me inside. Your gun law isn't my spot, man. How would a manufacturer make the serial number easy to remove when every number is verified before shipment? You can't think of any way to do that? You can't think of any way that a manufacturer could make a serial number easy to remove after it was shipped? It was verified when it was shipped. You can't think of any way a manufacturer could, in theory, make the serial number easy to remove after that point. It was verified once it was shipped, man. You can't think of any ways. Really? Try harder.
And abetting to the extent that Congress mentions that in an example in the statute. So what we're really doing is trying to understand what Congress intended with respect to the
Now I disagree. What do you disagree about? There wouldn't be a record at all? Why? Why wouldn't there be a record at all? I mean, I suppose the manufacturer could make it without a serial number. They could do that, but that's not what we're talking about. We're talking about a serial number that's easy to remove. So why wouldn't there necessarily be a record of it? Why wouldn't it be that there would be a record of it when it leaves the factory with its serial number, which then at some later time could be easy to remove? Why wouldn't that be possible? I don't understand. What are we talking about? What are we talking about? I don't understand. Like exactly right. They wrote it on with dry erase. Yeah, I mean, economath, it's like we don't have to make this particularly difficult. Yeah, they wrote it on with dry erase. They wrote it on a sticker. They wrote it with pencil. I mean, what are we talking? They literally just put a tag on it, with a zip tie that has the serial number. That's the way we're going to serialize it. We're going to put it on a zip tie, and we're just going to attach it to the trigger guard, and that's the serial number. And we'll record it, and we'll record it when it leaves the factory. I don't. What are we doing here? What's going on in chat? You guys are killing me. You're making me die inside. That's assuming our companies are complicit. It's absurd. That was the hypothetical. That was the hypothetical. It's a what if. What if? What if they did that? What if that happened? And do you really think it's beyond the pale that there's some manufacturer somewhere who hasn't skirted a law or a regulation on some time? Do you really think that every single gun manufacturer ever, even in the United States for that matter, even US based manufacturers will make it easy, like let alone foreign manufacturers? Let's just stick to US based manufacturers. Do you really think that there's never been any US based manufacturer who hasn't perhaps skirted a reg or a rule, or just like openly broken a reg or a rule? You think like that's never happened? You think that's impossible? What are we talking about, man? What are we doing here? Pity the Gilbert. You guys don't understand how hypotheticals work. You guys are killing me. The serial number has to be made a certain depth of the frame and barrel. It can't be made any easier to remove. It's verified before the gun before it's allowed to ship. Really? Are you sure? Because that doesn't sound right. So let me just make sure I understand what you're telling me. Are you telling me the government verifies every single gun to make sure the serial number was made in compliance to the rule before it ships? That's what you're telling me? It's verified before the government before it's allowed to ship? You're telling me that the government verifies every single gun to make sure the serial number is made in accordance to the reg before it's allowed to ship? Is that what you're telling me? Because that sounds like some bullshit. That sounds like some bullshit. That doesn't sound like that's a thing that happens. They verify every single one, really? Sure, are you sure about that? Because that sounds like some bullshit.
That it put in this statute. And so to the extent that it references aiding and abetting liability in one of the examples, that is just to illuminate the meaning of the statutory terms that exist there, right? I mean, it's sort of odd to me that suddenly a common law of aiding and abetting liability is coming in to, in your view, be dispositive of how we think about it.
Yes, 100% research. Every gun is required to be approved to leave the factory. It's not a government employee. You mean it's someone who works for the company? The company that wants to defy the regulations? The company that presumably is explaining to the tech what the rule is, because the tech probably doesn't know all the gun regs off the top of their head. They just manufacture guns. They don't really, they probably don't know all the, so the person who has to verify it presumably is being told by the company what they have to verify. The company in this hypothetical that wants to skirt the reg or defy the reg, who then presumably would explain to the person verifying it, oh, that's not a reg anymore. Okay.
About this case.
Sure. Well, I think that it's an example that the reference to aiding and abetting in the statute is an example of a violation that then triggers.
Quality control departments are in most manufacturing. You guys aren't getting it. Quality control. Okay, how does the quality control do their job? Aren't they told what the quality is supposed to be? That's the dumbest argument I've ever heard in my life. Don't you know there's quality control? Sure. Who tells the quality control what it means to have a quality item? Who tells the quality control what to do? Isn't that the company? Isn't it the company that says, hey, our products need to be quality. Here's what we want them to be. Here's what to look for. You got it, boss. Got it, boss. Isn't the quality control just the company who's now is trying to what yeah. Big Rig 0485 says the government has never worked with the manufacturer to make almost untraceable weapons, then given them a cartel. That too, I'm sure. Also that. Quality controls have to be approved by the ATF. I'm going to storm out of this chat. I'm going to storm around. Okay, so you're trying to tell me the ATF reviews the quality control process of every single gun manufacturer, and also they would know if the gun manufacturer changed it and also didn't tell the ATF? What if they did? What if they didn't tell the ATF? How does the ATF know when it's changed? How do you know the company didn't tell the ATF something and then told their own people something different? You're trying. What are you talking about? No one's ever lied to the government before, including gun manufacturers. No gun manufacturer would ever lie to the ATF. That's impossible. That's impossible. There could never be a gun manufacturer who could ever lie to the ATF. There's never a gun manufacturer who would say, "Here's our quality control," even though it's really not. That's impossible. That could never happen. No one would ever lie to the government in order to try to get away with something. People are always honest to the government when they're trying to get away with something. We changed our regulations. So instead of engraving the serial number like we used to, we're now going to put it on a tag that we attach with a zip tie. Hey, I'm the ATF. You weren't allowed to do that. You weren't allowed to do the zip tie thing. Oh, geez, that's okay. I'm going to make sure not to do that. Yeah, I'm definitely going to run off to the ATF and tell them about my zip tie serial number scheme. That definitely seems like a kind of thing I'm definitely going to actively tell the ATF about. That seems like definitely a thing that's going to happen. Lol. Brian Allman says, short version of what Kurt's saying is people and companies lie almost all the time. Well, they can lie. Not necessarily that they do lie all the time. I'm sure there's a lot of manufacturers who are, flying straight and, and doing right. I'm not saying that every company lies. I'm not even saying most companies lie, but to assume like it's impossible, it's like, or like even it's just not a guy working the line without knowledge of the company. How about that? Maybe it's just a guy working on the line who maybe with his buddy in quality control, lol, decides to manufacture a few firearms that aren't quite up to spec, maybe with the hang tag serial numbers, without any particular knowledge of the company. That's impossible. No person working for a company would ever do anything other than doing exactly what the company said. Every single employee always does exactly what the company says, don't you know? They would never skirt a process or do something for potentially nefarious reasons. No employee would ever go behind their company's back and do something other than what the company wanted. That's an impossible. What are you talking about? That's the wrong thing. Holy shit. Constitutional in chat for $10 says, I was an FFL 07 licensed firearm manufacturer, just like Smith & Wesson Remington, and short of having a design approved, and short of having a design approved and registered with BTF, which also, by the way, there's like no way that, the company or the person working in the line would ever do anything other than what they told the ATF about. Yeah, ATF, here's my plan. I'm going to make this gun. This is the gun I want to make. ATF says, cool, that looks good to us. Yeah, there's no possibility then that the company nor potentially the guy working on the line would ever do anything different than that. There's no possibility that they might have lied or misled to the ATF. This is impossible. Also, it was a hypothetical. What if? You really think someone would do that? Just lie to the government? I think it's possible. Lol.
The statutory exception and the proximate cause analysis. So you have to understand then what it means to aid and abet a particular crime. Again,
as Congress
my point was all I had to do was keep records. I'm on your side. Yeah. Right. Yeah. Yeah. It's not possible that any company would ever lie in its official records. That's never happened before. No company would ever lie in its official records, nor would any company ever give one set of books to the government while keeping another set of books for themselves. No company has ever run two sets of books before or kept two sets of things, one for the government, one for themselves. That's never happened before. The IRS, by the way, is very happy to learn this information. The IRS is thrilled. They don't have to worry anymore because people will always tell the IRS exactly what they earned, and every single company will always turn over their one and only set of books to the IRS. So the IRS has nothing to worry about. Everything's fine.
Candidate for the purpose of this statute.
Well, and I think it's not that plausible to say that Congress had some completely idiosyncratic view of what aiding and abetting was for the statute, as opposed to just looking to the principles like this court looked to in Twitter, which are just the basic aiding and abetting.
Can I just ask you about your proximate? Can I ask you about the proximate cause? Because I'm still a little confused about where you start your proximate cause analysis. I listened as you discussed with Justice Thomas the series of steps from your clients to the alleged ultimate harm. But it seemed to me that the first moment of illegality in the chain, that, as you articulated it, was the retailers selling to the straw purchasers. Am I right about that? You say your clients do things that are legal. They sell to other legal buyers and et cetera, until we get to that straw purchaser point, right?
That is the first moment of illegality, but I don't think that's the sole step relevant to a general proximate cause analysis.
Right, but we don't have a general proximate cause analysis. We have a statute, and the statute makes clear that we're starting with an action in which a manufacturer or seller of a qualified product knowingly violated a state or federal statute applicable to the sale or marketing of the product. So it seems to me that the first step, given this statute, is the moment of violation, of illegality, as opposed to some theoretical original point.
Well, I suppose that's true in some sense. I mean, the first step is the moment of violation, the moment of illegality, because we need to find a violation of the state or federal law. That's true. But if you want to come up with some special, exciting interpretation of aiding and abetting, like aiding and abetting is generally defined. I think even Justice Gorsuch pointed out 18 U.S.C. Section 2, I think. So, like, if you want to say it's something different for the purpose of this statute, though, why? So, yes, the first step is who broke the law. And if it's not the manufacturer who broke the law, then how are we getting all the way back to the manufacturer? So, yeah. Yeah, I mean, you know.
And my answer to that question is no, but it doesn't matter.
No, I understand you think you make it anyway, but I'm just trying to understand why you're insisting that it's way back here.
Because what the statute says is there has to be a proximate cause between the defendant's violation. Our violation is not the illegal sale itself. We don't sell to consumers.
But you say you don't violate at the beginning, so I don't know what your violation is unless it's the point of illegality.
It's the aiding.
I'm being overly sensitive. First of all, I don't appreciate being told how to feel. That's not very nice. I'm allowed to feel certain ways. Second of all, I'm responding to people in chat and what they have to say. And I'm responding to them by saying what they're saying doesn't make sense. I'd like to think in a very logical way rather than an emotional way. I'm not really appealing to emotion. I'm appealing to logic, reason, and facts like that. And I'm having some fun along the way, but I don't think I'm being overly emotional. Oh, not me? Okay, yeah. It's like I'm just responding to people in chat, and people in chat are saying things, and I'm like, I don't agree with you. Let me tell you why I don't agree with you. Here's why it doesn't work. And then someone in chat says something else, and I'm like, I still don't agree with you. Let me explain why. And someone in chat says something, I'm like, I still don't agree with you. Let me explain why. So, you know, that seems like a good thing to do. Yeah. Yeah, they're talking to another chatter. Yeah, sometimes it's not clear who's talking to who, right? It's just like, okay, well, I'm just trying to explain why what you're saying doesn't really make sense to me. And like also reading super chats, because that seems like a polite thing to do. I read your super chat and then I respond to your super chat. And if I don't agree with you, I explain why I don't agree with you, and I tell you why what you're saying doesn't make sense. And it seems like a good thing to do. I mean, okay. Who's handsome for $1.99? Thank you very much. I can't win, I swear.
And abetting. That is the whole aiding and abetting theory.
Thank you.
Thank you, counsel.
Thank you, Your Honor.
Ms. Stetson?
Yeah, okay. So finally reaching the end of this section of the argument, finally. It was 40 minutes of oral argument, and we've been talking for an hour and 40 minutes. Outstanding. That's how much you guys have distracted me. You've distracted me by 150%. Yeah, so I'm still back with, okay, we need to find a violation of the law. And if you think the manufacturer broke the law, how? If you think it's aiding and abetting, what is their proof that they had knowing and all the rest of it, and so forth and so on? So, I mean, I sort of agree with Smith and Wesson on this one. Let's see what the opposing side has to say about it.
Mr. Chief Justice, and may it please the Court, Mexico's complaint pleads that petitioners aided and abetted violations of specific federal gun laws, and that those violations proximately caused Mexico's harm. That satisfies PLCAA's predicate exception. First, the complaint details that petitioners deliberately supply the illegal Mexican market by selling guns through the small number of dealers that they know sell a large number of crime guns and who repeatedly sell in bulk to the cartel traffickers. Petitioner's arguments ignore these allegations.
Okay, I mean that makes more sense. So if they're not characterizing it correctly, then I suppose my question back would be the prima facie, right? Because you can't just say things. You have to have the prima facie. It's known as pleading, so you don't have to go into hyper specifics, but you do have to provide enough information to provide the prima facie case that is true. You can't just say they know. It's like, okay, how do they know? How do you know they know? What is your prima facie? What is your proffer for that? And if you have that, then I guess, go forward with the lawsuit. That makes more sense. So, okay, if that's what you're trying to tell me happened, then, fair enough, I suppose. If you have evidence that Smith & Wesson knows these dealers are selling to the cartel and so forth and so on, then okay, that makes a lot more sense for aiding and abetting. We still could get into the proximate cause issue, which is a separate issue, but at least now we found the crime. And then we could have a proximate cause discussion on top of that. But if you think that's true, then that makes a lot more sense. So, okay.
Next, as the court said in Twitter, an aider and abettor is liable for harms that were a foreseeable risk of that violation. That framing, foreseeable risk, is the proximate cause question.
Okay.
As this court put it in Bank of America, does the harm alleged have a sufficiently close connection to the conduct the statute prohibits? The answer is yes. The laws broken here are designed to keep guns out of criminals' hands. Those violations put guns in criminals' hands, and those criminals harmed Mexico. Petitioners' arguments would rewrite PLCAA and proximate cause law far beyond this case. Petitioners argue that independent criminal acts sever the causal chain. But an independent act, criminal or not, only breaks the causal chain if it is not foreseeable. These acts were foreseeable. Petitioners argue that Mexico's injury is not direct, but their directness argument borrows from cases involving indirect victims. Mexico is not an indirect victim. We are here at the beginning of this case. This court need not vouch for Mexico's allegations, but it must assume they are true. And the issue at this stage is not whether every aspect of Mexico's complaint survives, but whether any of it clears the predicate exception. Mexico should be given a chance to prove its case. I welcome the court's questions.
Not an unreasonable argument. And the proximate cause issue also can get tricky. It would be interesting for a court to try to dismiss it on failure to state a claim for failure to show proximate cause. That would be challenging. I'm not necessarily sure it's impossible, but it would be challenging to dismiss for failure to show proximate cause. So on a motion to dismiss standard, we do have to assume their allegations are true if they make any logical sense, and as long as there's some evidence to support their proposition. Again, they don't have to provide everything, but they can't just say they know. They have to provide some basis for that knowledge. And okay, so maybe there's enough for the lawsuit to proceed if that's true. But Smith & Wesson very strongly disagrees with how this is characterized. So let's see what Mexico can bring to the party and see if they can tell us that Smith & Wesson is making the case in bad faith. We'll see. You don't see standing? No, I don't think standing is the problem. Although it's arguable that the injury to Mexico is indirect rather than direct. It's arguable it's indirect, but I'm not sure standing is the problem, but proximate cause might be. Let's work on this a little bit.
How is your suit different from the types of suits that prompted the passage of PLCAA?
Our suit is different, Justice Thomas, because the types of suits that prompted the passage of PLCAA specifically did not allege that the manufacturers had violated any law. So if you look, for example, at the Third Circuit's decision in City of Philadelphia, the Illinois Supreme Court's decision of City of Chicago, each of them specifically made the point that those manufacturers were not alleged to have violated any federal or state statute. They were being held liable for actions solely caused by criminals. And that's the important balance that this bipartisan act struck. If an action was solely caused by criminals, manufacturers of guns, like any other product, wouldn't be held liable. But
well, it seems as though the only connection or the difference would be the allegation or the assertion that you have an aiding and abetting problem with respect to the manufacturer. You could have done that in the other cases, couldn't you?
I don't know that they could have, and they certainly didn't. And PLCAA, for more to the point, could have also barred, as many states did, all lawsuits against manufacturers. Many states barred lawsuits by cities. Many states barred lawsuits by all manufacturers. PLCAA didn't. And what PLCAA did was to preserve exactly these types of claims. You asked a question about the specific allegations of illegality. I want to direct you to paragraph 249 of the complaint. There is a list at paragraph 249 that includes 18 U.S.C. 922, several different subparts, A6, D1, 923 G1, 924A1A, and those map closely onto the predicate exception we're talking about, including, of course, that first example of the predicate exception, which involves aiding and abetting a straw purchase, which is at the core of what we are talking about. That's 18 U.S.C. 922A6, 922T1, 922M, 924A1A, 923G1A. Each of those are slaint, and the manufacturers and distributor in this case are alleged to have aided and abetted all of them.
All right. I might have to actually pull the underlying complaint and take a look at that because that's interesting to me. So paragraph 249 of the complaint, we may have to pull the underlying complaint and read paragraph 249. Try to see what evidence on the prima facie they have for aiding and abetting. So, okay, fair enough.
I'm sorry.
Just one last. Have any of these violations been violations that ATF has pinpointed?
They have not been violations that ATF has pinpointed, and that's a point that the petitioners are fond of making. I think the issue with ATF, as the complaint alleges, is that ATF, and you can find this at paragraphs 126, 129, 133, ATF, just because of its resources, is only able to look, even every year, at about anywhere between 3 and 10% of licensed dealers and manufacturers and distributors. And if PLCAA, again, had wanted ATF to be the sole arbiter of this, it could have barred cases altogether. It could have required a conviction. It could have required the stripping of a license before any of these allegations were allowed to go forward. It didn't do any of those things in the predicate exception.
Counsel, in his argument this morning and also in his brief, Mr. Francisco focused on two particular cases, the Twitter case, of course, and you engaged with that in your brief, but also Hemi Group, and you cite that once in a string cite at page 42 of your brief. I wanted to give you an opportunity to say a little bit more about that.
Certainly. So Hemi Group, of course, pertains to the proximate cause issue. And Hemi Group, I think, is in a line with all of the cases that talk about what my friend Mr. Francisco calls direct harm. And that's something that you heard a lot in his argument. Direct came up a lot. Independent came up 13 times. Direct harm, if you look at Hemi Group, if you look at Associated General Contractors, Holmes, ANZA, Bridge, there is a list of proximate cause cases. And if you look at each of them, what you will find is that the issue there was that the victim who was bringing the complaint was an indirect victim. So this court, like many of us, finds it hard to speak with one voice on proximate cause. One of the few times it has is in Lexmark. And what Lexmark says is the reason for that directness requirement is that there ordinarily is a discontinuity between the injury to the direct victim and the injury to the indirect victim, so that the latter is not surely attributable to the former. That, I think, is an important component of the proximate cause argument, and I want to touch on this independent idea because it came up so much. As I said in the opening, an act that is independent can still be foreseeable. It's when an independent act is unforeseeable that you have the intervening cause that breaks the causal chain. So Mr. Francisco.
Andy B, the precedent would be so bad? Well, I don't know. It depends. We're trying to follow the law. And what she's saying, if what she's saying is a fair characterization of the complaint on a motion to dismiss, then it sounds plausible that this case should go forward. Because a motion to dismiss, you have to conclude that, it's basically void. It makes no sense on its face. And so you either have to conclude that there isn't sufficient evidence presented to make even the prima facie case, or it just is just makes absolutely no sense. Basically, it's crazy, or there's some sort of legal defect. But if she's right about the way the complaint is if she's right about the complaint, if she's provided the prima facie complaint to say that Smith & Wesson aided and abetted with knowledge, particular knowledge of the manufacturer, if they did that, and there's enough evidence to get you past go, then it sounds like the lawsuit should probably continue. The only other reason to not let the lawsuit continue would be to say that as a matter of law, it's so attenuated that fails proximate cause. That sounds a bit challenging as a judge. I'm not saying it's impossible. It sounds challenging as a judge to be able to make that decision, on the complaint. As opposed to being able to make that decision later down the line. So, yeah, I mean, maybe the lawsuit should go forward. We're trying to find the right legal answer. That's what we do. But one of the main purposes of the product is to kill things. How's the outcome not foreseeable? That's a really fucking stupid argument. The product does exactly what it's supposed to do. That the product is operating correctly. It is not foreseeable. It is not inherently foreseeable that the gun is going to wind up in the hands of a criminal who's going to break the law with it. That's really fucking dumb. And if it were correct, that would be the same for the beer manufacturers because people drunk drive. It would be the same for car manufacturers because people drive irresponsibly. It would be the same for. It doesn't make any sense. Yeah, it doesn't make any sense.
Mentioned that 1876 case that Justice Gorsuch did not write about Milwaukee Railroad. That is the case that says the primary cause may be the proximate cause of a disaster, though it may operate through successive instruments, as an article at the end of a chain may be moved by a force applied.
Couldn't it always be foreseeable that a dealer might be involved in a straw purchase? I don't really think that works. There's always a chance it might happen. We just hope the threat of jail and losing FFL prevents it. Yeah, I don't really think that works, MG Law, with respect, because again, it's kind of the same problem that you'd run into for Budweiser, right? Budweiser has knowledge. They have knowledge in a general sense that some bars will overserve their customers. Some bars won't check IDs. Some bars will let people drink underage, right? So it's the same sort of thing. Like that generalized knowledge doesn't get you anywhere, because it's like, as Budweiser, what am I supposed to do? How am I supposed to solve this problem? What am I supposed to do? And there's nothing for me to do. And if I can't fix it, then it's not really fair to impose liability on me, right? There has to be something I can do. It's like, what am I supposed to do here? So like the generalized knowledge that, people will drink underage and bars will overserve them and bars will let underage people drink and then overserve them and so forth and so on. Like it's way too generalized to impose liability. It doesn't make sense to me. And for the same reason, that sort of generalized knowledge doesn't make sense to me in the manufacturer case either. There's no way for me to fix it. There's no way for me to fix it. And if I can't fix it, it's not fair to impose liability on me. That doesn't make any sense. To my mind.
To the other end. So it's not a question about one step or a causal chain. It's a question about whether something breaks that chain. Hemi was an example of something breaking the chain because you had unlawful conduct over here and an injury over there, and the two weren't connected by anything other than a very articulate series of steps. The injury and the conduct were very different.
It's nearly impossible to say that something's not foreseeable in a chain. It doesn't help me when people talk foreseeability. I'm much more helped by the restatement third of torts that basically says you impose liability for harms within the scope of the risks that made the defendant's conduct wrongful in the first place. That makes much more sense.
MG law says unless they can name specific dealers the manufacturer actually knew were engaging in straw purchases and continue supplying, they have no case. Yeah, that sounds correct to me, right? But that's sort of the representations she seems to be making. Like, that's what they said in the complaint, which is like, okay, well, let me go, when the stream ends, we'll probably go back and try to read the original complaint. We'll pull it up and, pick it up in Pacer, and we'll go like skim it, at least paragraph 249, and try to see what they're saying. It's like, what are they saying exactly? And it's like, if her representations are correct, the lawsuit sounds plausible. If Smith and Wesson's representations are correct, the lawsuit sounds non-plausible. So it's like, well, we might have to go back and read the thing, because maybe we have to read the thing and to figure out which of those two universes we're in. And try to figure it out from there.
Because, as I started earlier with Mr. Francisco, we know that a straw seller is going to sell to someone who is going to use the gun illegally. Because if they weren't, they wouldn't use the straw purchaser. And that illegal conduct is going to cause harm, and harm like this, that the gun is going to be used in some way to injure people. Correct?
That's correct.
And that basically is much easier than saying that all foreseeable harms are you're responsible for all foreseeable harms. You're only responsible for those that your wrongful conduct causes a risk about.
That's exactly right, Justice Sotomayor, and that's why I started with that reference to Twitter, because when Twitter talks about the aider and abetter being responsible for
Guru for Hire says we can't have gun stores in bad neighborhoods. No one said that. And I don't. That kind of comment really bothers me. It's like you're going to an extreme that no one is talking about. I will tell you this: the gun store in the bad neighborhood has to follow all the laws. And they can't knowingly sell to a straw seller or straw buyer. They can't knowingly or with willful blindness break any other relevant law. But that's completely separate. No one's talking about that. What are you talking about? It doesn't make sense. No. The example doesn't flow from anything. It's such an extreme hypothetical. It's such an extreme extrapolation of what we're talking about. It's not a good way to show critical thinking. Don't do that. It's not a good way to think, man.
for harms that are a foreseeable risk of the conduct. That's the closest thing that I've seen that comes to encapsulating what a proximate cause test is. It's foreseeable
Now, can I
risk.
go back to what's troubling me? You have the manufacturers aiding and abetting, in your theory, by producing guns that are singularly attractive to the cartel because they're designed in a particular way that cartel members like because they're showy.
if that's the theory of the crime, Mexico can bite my ass. They're liable because the guns are showy. What the actual fuck? What the actual fuck?
They're making erasable serial numbers.
That's not possible, Justice Sotomayor. I've been reliably informed by Justice Sotomayor. I've been reliably informed by some people in chat that is simply not possible. It is not possible for a gun manufacturer to make easily erasable serial numbers. That's not possible. That can't possibly be a thing. Lol.
Which obviously are attractive to criminals because every criminal would like to erase the serial number if they can. So that's what you claim is aiding and abetting. But what are you claiming Interstate, the distributor wholesaler, did? Other than selling the product, they don't design it. They didn't do any of the, they didn't design it. They didn't have anything to do with that. They just have a product they're selling. So how do we make, how are your allegations enough with respect to Interstate? And if we were to say they're not enough with respect to Interstate, doesn't that break the causal connection with the manufacturers?
If you want to narrow Wickard v. Filburn, I am here for it, Justice Sotomayor. I am here for it. If you want to say that this doesn't qualify as interstate commerce, I'm here for it. Let's go.
Justice Sotomayor, the complaint actually details 6 or 7 different examples of how the manufacturers are actively participating in the illegal market. One of them is design. Yes, yes.
I'm asking, tell me what it says that the distributors are doing.
What it says the distributors are doing, including the one that's named in this complaint, are knowingly supplying the dealers who we know sell unlawfully across the board.
But knowledge is not enough. We have repeatedly
Well, that would be
said,
interesting. So Justice Sotomayor seems to be going for some sort of theory where the gun manufacturer is responsible, but not the distributor, even though the distributor probably would know also that the guns are flashy and stuff, and particularly desirable to cartel members. I mean, if the manufacturer knows that, presumably the distributor knows that. I mean, it's their job to figure out what guns are going to be popular in the market so, that they, get money and stuff. But she seems to be going for some sort of theory where the manufacturer is responsible, but the distributor isn't. Interesting. Okay. Not sure about that one, but all right, let's press on.
Mere knowledge is not enough. You have to aid and abet in some way. You have to intend and take affirmative action to encourage not to encourage, but to participate in what they're doing.
What this court said in Rosemond is a person who actively participates in a criminal scheme, knowing its intent and character, intends that scheme's commission. That's the criminal aiding and abetting standard.
Yeah, that is the standard. That was a question I wanted to circle back with you on, Ms. Stetson. And that, if 922 and 3 and 4 are your predicate violations, and aiding and abetting under 18 U.S.C. Section 2, I think, would then be your aiding and abetting hook. Those are criminal statutes, and the mens rea under Rosemond is intent, right?
The mens rea under Rosemond for aiding and abetting in the criminal context would be intent.
And you're invoking criminal statutes, so is that the standard you have to meet here?
It's the standard we have to meet. But just as in Rosemond, if you actively participate knowing the scheme,
sure, then you can infer
then
knowledge.
you can infer
I
intent,
get
particularly
that.
at the motion to dismiss stage.
Yeah, got it.
And let me, if I could, I want to be pretty specific about some of the allegations in the complaint, because what I heard this morning was that the allegations are vague and so forth. I want to point you to a few particular allegations. Two of them are at paragraphs 122 and 146, and this has to do with trace data. Defendants are alleged to regularly receive, paragraphs 122 and 146 I'm starting with, regularly receive even more direct information about problem dealers. Trace requests from ATF and other agencies alert defendants that guns they sell to specific distributors and dealers are being recovered at crime scenes. Paragraph 146. Authorities have repeatedly identified and recovered defendants' guns in connection with notorious gun trafficking rings. Paragraph 232, defendants are aware that specific networks of distributors and dealers they were supplying were consistently channeling their guns. Paragraph 233, Century Arms received communications from ATF. Those trace requests revealed that specific distributor and dealer networks were disproportionately associated with those guns. Paragraph 234, all of the other defendants have access.
Specific distributor and dealer networks are disproportionately associated with those guns. Yeah, I think I need the complaint.
To the same information. That is exactly the kind of specific allegation in the complaint at this stage that satisfies a motion to dismiss.
But that
Access to knowledge is not the same thing as having knowledge. It would be if you can show willful blindness. If they were purposefully not looking, it would be the same. So there's that. But yeah, we may need the complaint. The stream may go longer. If you guys want the stream to go longer, we can go longer, and we may have to go to the complaint. I'm trying to debate whether or not it makes more sense to go with the First Circuit decision first, and then maybe go to the complaint, because the First Circuit decision may clarify some of these issues. It might be more efficient than going to the complaint. So I'm trying to decide whether or not I should just go to the First Circuit first, or whether or not I should just skip that step and just go to the complaint. So I'm not sure which makes more sense.
Those statements aren't allegations of violations of the law, correct? I mean, those statements just go to whether or not the defendant had knowledge that at the end of the day, some dealers might be doing something wrong. These guns.
Again, Guru for Hire, it's not about selling guns in bad neighborhoods. That's not the issue.
That they're selling are ending up in the wrong hands. But I took the statutory language here to be requiring more in terms of violation on the part of the defendants in this case.
It certainly requires, Justice Jackson, a knowing violation. But as far as these allegations go, what these allegations show is that the dealers, a small number that is responsible for the large number of guns, are knowingly violating federal laws, and that these suppliers, these manufacturers and the distributor, know that is happening and continue to actively supply. And I want to
what you don't have is particular dealers, right? I mean, it's a pretty, there are lots of dealers, and you're just saying they know that some of them do. But which some of them? I mean, who are they aiding and abetting in this complaint?
Good question.
There are a number of dealers that we do know are responsible for selling a great number of crime guns into Mexico. There's the Washington Post article that the complaint mentions. That names 8 or 10 different dealers by name, most of which are still very actively in the business. And more to the point, again, we are here at a motion to dismiss. What we have alleged is that these manufacturers know from ATF exactly what dealers are the problem, are the rogue dealers.
Alleged based on what exactly?
So the hypothetical that you gave Mr. Francisco, Justice Kagan, is not a hypothetical. That is actually this case. The allegations in this case establish, for purposes of getting past the motion to dismiss on the predicate exception, as Justice Jackson mentioned, that there are allegations of aiding and abetting, violations of federal laws. And I want to get back to a question that Justice Barrett asked as well about what the violation is, because I think there's been some noise in the data.
Ms. Stetson, before you do that, could I just ask you something related to the point you were just discussing? Are there any allegations in the complaint that the petitioners knowingly sell to specific red flag dealers?
Yes. If you look at paragraph 247, and I'll read it because I think this one is important. Defendants supply dealers with all the guns they can pay for, without any public safety conditions, even if a gun dealer has been repeatedly found to have violated gun laws, been indicted, its employees have had federal gun licenses revoked, or has repeatedly supplied cartels in suspicious and obvious sales to traffickers, including repeated bulk sales. That is an allegation that goes directly to specific.
Well, do they know about repeatedly supplying cartels? And if your prima facie is based on the Washington Post said it, I feel like I'm going to need more than the Washington Post said it. Yeah. Okay. All right.
Rogue dealers. And that gets us, I think, to the Twitter direct sales dichotomy. What Mr. Francisco says is that Twitter was very actively managing something. Twitter was actively managing, to the extent it was managing anything at all, its algorithm. And what this court said in Twitter was that kind of starting the platform, sending it out into the world, and standing back and watching, which was the phrase in Twitter, is not enough. What you need is active, culpable participation. The active, culpable participation here is continuing to sell guns to rogue dealers that you know are the problem dealers.
You
that
haven't
is exactly
identified
direct
the
sales.
dealers. Justice Alito was asking you about specific red flag dealers, but that paragraph doesn't identify dealers, and it seems to me that that's one of the distinctions between this case and direct sales, and for that matter, this case in Twitter. Let's talk about Twitter. There was a specific rogue actor, ISIS, and there was a specific attack in France. And so the attempt was to draw the line between them, and we said it wasn't enough. In direct sales, there was a specific manufacturer, pharmaceutical company selling to a specific doctor, causing specific harm. And Justice Alito asked you what specific red flag dealers there are. You haven't sued any of the retailers that were the most proximate cause of the harm. You haven't identified them that I can tell in the complaint.
Justice Barrett, there are many, many paragraphs that specifically identify rogue dealers in the complaint. If you look at approximately paragraphs 147 to 203, they identify specific dealers that have been found to have sold guns in bulk to traffickers that go across the border. If the question is, you haven't named in paragraph 2.
They identify specific dealers that have been found to sold guns in bulk to traffickers that go across the border. Found by whom? Who found it? Did Smith & Wesson know that, or were they willfully blind to that?
47, which says that these manufacturers know that they're selling to dealers who sell to cartels. I think that is pushing a little bit past what is necessary for drawing reasonable inferences from a motion to dismiss. But I want to pause, too, on Twitter and direct sales. Direct sales involved an entity that was selling large quantities of morphine.
Yeah, Amanda, I think we're going to pull up the complaint after the end of the stream and try to look at some of these paragraphs and see what they're talking about. I think that's the only way we're going to be able to try to figure this out from first principles, is to try to look at the complaint. So I think we're going to do that at the end of the stream. If you guys continue giving me super chats. If you guys continue supporting me, I'll give it a look.
To a doctor. The entity was licensed, the doctor was licensed. And if you look at direct sales, what direct sales says is that the quantities that were at issue were in line with that defendant's marketing practices. There was nothing unusual about the quantities at issue there. What was unusual in that case, and what is different in that case, is that the direct sales manufacturer did not know that that specific doctor was a problem. It had been put on notice that there were other doctors who were selling lots of their products to people who shouldn't be getting them. But unlike this case, where these manufacturers and the distributor are alleged to know who the dealers are and what problems they are causing, the manufacturer that was held liable for criminal conspiracy in direct sales didn't know anything about that doctor. All it knew was that the doctor kept sending them legal order forms, and they kept fulfilling the orders. That was direct sales. This case is much like direct sales, if not stronger, for that reason.
What do you do with the suggestion on the other side and in the amicus briefs that your theory of aiding and abetting liability would have destructive effects on the American economy, in the sense that, as you've read in the briefs, lots of sellers and manufacturers of ordinary products know that they're going to be misused by some subset of people. They know that to a certainty, that it's going to be pharmaceuticals, cars, what you can name, lots of products. So that's a real concern, I think, for me, about accepting your theory of aiding and abetting liability. And relatedly, you've referred often to the motion to dismiss. Of course, as you're well aware, getting past that is often the whole thing. So I don't think we can just rely on the motion to dismiss. But the broader point, I'd be interested in your reactions, how we
Thank you, War Hippie, for the contribution. Appreciate it.
But don't cause that problem that is identified with great force in the briefs.
Sure. So let's take Budweiser as an example. As you heard Mr. Francisco say today, if Budweiser had was alleged to have a practice of selling bulk quantities of Bud Light to liquor stores that were arranged next to high schools, and it was selling more and more into those high schools, knowing that those liquor stores were regularly serving underage students. And in fact, the Bud Light decided to put out a new can that says "Best Prom Ever" and sold it right into that high school. That is the allegations in this case.
Is it the allegations in this case? Because if it's the allegations in this case, I'm probably ready to side with Mexico on this one. Is it the allegations in this case? I don't know. I guess we'll find out. But if that's the allegations, then I'm probably ready to side with Mexico. But I have some doubts.
If you have a product manufacturer of a dangerous product that is alleged to have done all of the things knowing who they're selling to and what is being done with that product, then and only then, I think that product manufacturer has a problem. If you look at the examples that are given.
Big Rig says that sounds like selling guns in a bad neighborhood argument. It's not the bad neighborhood. That's the problem. I'm going to lose my mind. It's not that the store is right next to the high school. It's that, all the other things. That's the problem. Chat, I think you and I need to have a conversation. I'm not sure this relationship is working out for me. We need to talk.
In PLCAA that aren't at issue in this case. The examples that the congressmen and senators were concerned about in PLCAA were when a car dealer sells a car to someone who later drives drunk, when Campbell's is sued because someone is killed with a soup can. Those are the things that PLCAA was concerned about. This case marches through in detail allegations taken as true at this stage that these manufacturers know that they are selling a dangerous product to specific rogue dealers who are selling to straw purchasers for the cartels across the country.
What if a beer, I'm sorry, I cut off your sentence. Did you? What if a beer manufacturer knows that the per capita beer sales in a small college town are, 50 times more than another town without a college there? Is that enough?
I don't think that alone would be enough. I mean, you do have allegations in this complaint that the number of dealers that have arranged themselves along the border of Texas and Arizona of Mexico are vast. I don't think that itself would be enough. It would be, the dealers are there, what they're selling, who the bad apple dealers are. Because we're not talking about every dealer in the country. We are talking about a small percentage of retailers responsible for about 90% of the crime guns that are found. Those retailers in that college town, if you plug in that hypothetical of Budweiser, and Budweiser was marketing in with some kind of, best first-year homecoming ever, then you would again have the problem. But you'd have to have each of those specific allegations in the complaint that you have here.
Ms. Stetson, I guess what I'm concerned about, you talked in response to Justice Kavanaugh about what PLCAA was about, what it was getting at, and I really thought, as the statute itself says, that it partially, at least, is about Congress protecting its own prerogative to be the one to regulate this industry. That there were concerns, and the statute itself says that, we're worried that tort suits are an attempt to use the judicial branch to circumvent the legislative branch of government. And to me, when you think about that as being the reason why Congress wanted to have immunity in this area, and I'm starting from the, I'm sure, consensus view that we're trying to do what the statute, the statute wants. I think when you think about that, the predicate exception makes perfect sense to the extent that there is a violation of a state or federal statute at issue. Because Congress says we want to be the ones to regulate, but in this particular situation in which a tort suit aligns with a clear violation of the law, then we don't worry that we have judges and.
Oh, I just saw this in my. This is off topic. I apologize, but Judge Bev denied Bedrow as KR's attorney. Nice. After reviewing the pleadings, defendant's supplementation for admission pro hoc vice Bedrow is denied. The affirmation submitted in support of the motion is insufficient. In addition, proposed concurrent representation involves a conflict of interest that's not waivable. One such conflict is specifically outlined in the motion paragraph 8, where Bedrow, apparently speaking through Unetti, promises to restrict use of certain information. The clear inference of the promise is that Bedrow would not use protected information gained in the representation of one client for purposes of representation by another client. He thus purports to ignore information known to him through his representation of one client, either where the information might benefit a second client. The court cannot permit such a conflict. Love it. Love it. Fantastic. Awesome. Love it. Love it. Yeah. It could be correct, to be honest. It could be correct, but I'm getting a little hard to take Aunt Bev at her conclusions at this point. Yeah.
And the common law system dictating what people can do. I worry that without that clarity, in a complaint like yours, where we don't really see exactly how the manufacturers are violating a particular state or federal law, that we're running up against the very concerns that motivated this statute to begin with. So can you speak to that?
Sure. Justice Jackson, I think if you look at the paragraphs, let's call it 203 to 250 of the complaint, which pertain exactly to the violations of federal law that we started with, all of the specific.
Oh, this is good. Apparently it just gets better in Karen Reed case. Apparently, the special prosecutor had filed something to correct the record. Apparently, the prosecutor says he mistakenly accused David Yannetti of making an out-of-court statement on court TV when it was actually a recording of Yannetti speaking, presumably in court. It was made during a Zoom call with the court. You know, at this point, an unbiased judge might consider, in order to show cause to the prosecutor based on them recklessly making an argument in court without sufficient factual basis. That's a pretty big fuck up for you to spend an entire motion arguing and besmirching and attacking another attorney's representation. So an unbiased judge might consider, in order to show cause to the prosecutor. Anyone want to take bets on what the over-under of Aunt Bev giving an order to show cause is? Anyone want to give odds on that one?
Violations 922 subparts 923 924.
Is MG Law here? Tell me I'm wrong. Tell me I'm wrong, MG Law. I mean, if another attorney went into court and made an entire motion basically about how you've made these statements that have completely prejudiced and basically have openly in court now accused you of ethics violations, and then it turns out, whoopsie doopsie, nothing that was the factual basis of that motion actually happened. Tell me I'm wrong. When a fair-minded judge at least consider issuing an order to show cause for such reckless statements made besmirching another attorney in court, when a fair-minded judge at least consider doing that? Tell me I'm wrong.
What you will find is that there are plentiful allegations that these manufacturers, by knowingly selling to the rogue dealers that they know are selling to straw purchasers, are aiding and abetting that violation. Part of the problem
I understand, but I guess my point is that Congress didn't want like general aiding and abetting concerns to be what is imposing duties on these manufacturers. I mean, if you look at your lawsuit and what you're asking for changes to the firearm industry safety practices. You say not, putting these kinds of constraints is a thing that should give rise to liability. The distribution practices, the marketing, all of the things that you ask for in this lawsuit would amount to different kinds of regulatory constraints that I'm
honestly pretty pissed right now, by the way. I'm definitely more pissed than that about the bed row thing. The bed row thing is pretty reasonable. But this is like the second time or third time the prosecutors misspeak. Oh, I got the information from the government. No, I actually got it from the defense. Oh, the defense made these extrajudicial statements. No, they were actually judicial. They were in court. And not to put aside all the sloppiness in the underlying case already, I'm actually kind of pissed. I'm pissed because it's considered kind of a big deal to attack another attorney on ethics violations. It's kind of considered a pretty big deal, to say another attorney is behaving in an unethical manner. I mean, and then it finds out that, there was actually no basis at all. Not that you were wrong or mistaken or, but just basically it was just, you didn't pursue it with enough diligence. I'm actually pissed. I'm pissed. I need to reset myself so I can get back into this thing. Okay.
Sure. Justice Jackson, I think if you look at the paragraphs, let's call it 203 to 250 of the complaint, which pertain exactly to the violations of federal law that we started with, all of the specific statutory violations, 922 subparts, 923, 924. What you will find is that there are plentiful allegations that these manufacturers, by knowingly selling to the rogue dealers that they know are selling to straw purchasers, are aiding and abetting that violation. Part of the problem
I understand, but I guess my point is that Congress didn't want like general aiding and abetting concerns to be what is imposing duties on these manufacturers. I mean, if you look at your lawsuit and what you're asking for changes to the firearm industry safety practices. You say not, putting these kinds of constraints is a thing that should give rise to liability. The distribution practices, the marketing, all of the things that you ask for in this lawsuit would amount to different kinds of regulatory constraints that I'm thinking Congress didn't want the courts to be the ones to impose.
So let me answer the aiding and abetting liability point first, and then I want to answer your remedies point, because I think that's particularly important. Aiding and abetting, of course, was specifically contemplated in PLCAA in the first predicate exception itself. Any case in which the manufacturer or seller knowingly made a false entry, et cetera, or aided, abetted, or conspired with any person in making any false or fictitious statement. Aiding and abetting is baked into this.
I don't have any problem with aiding and abetting be baked into this. I have a problem with, apparently, we want to come up with new exciting interpretation of aiding and abetting. Aiding and abetting could theoretically mean something different in this statute than other statutes, but what is your justification for that read? Why do you think aiding and abetting means something different here than it generally means in any other context? It could, but why? And if it doesn't mean something different, then what's your evidence for aiding and abetting? With knowingness and all the rest of it. How do you know that? And what is your prima facie proffer for that? Because you're not just allowed to say it. You gotta, it is notice pleading, but you gotta come forward with something. You don't have to put all your cards on the table with something that says this is why we believe it. And if your proffer is the Washington Post, I'm going to need you to do better. Sorry.
You don't read that to be very, very closely tied to the record-keeping violation or the particular statutory violation that's also mentioned.
No, that the predicate exception begins by talking about the action in which the manufacturer knowingly violated, and the violation was a proximate cause, including the exceptions that are mentioned. So aiding and abetting these violations of federal and state statutes pertaining to guns is exactly what this exception was built to do. That is why it was carved out in this bipartisan legislation. But on your remedies question, one of the difficulties, I think, for all of us is that we're here so early. This is a complaint that has asked for a number of different remedies, including a number of different types of injunctive relief. And one of the things that you heard the petitioners and a lot of their amici in their briefs complain about is what these remedies might do. That is for the district judge on remand to make sure that the judge equitably crafts a remedy that is designed to limit the harm to Mexico. Mexico is not trying to legislate gun use in the United States.
Yeah,
it sounds like they're trying to legislate gun use in the United States a little bit, to be quite honest. But sure, let's go with that.
I understand that. I guess I'm just wondering whether the PLCAA statute itself is telling us that we don't want the courts to be the ones to be crafting remedies that amount to regulation on this industry. That was really the point of the entire thing. And so to the extent that we're now reading an exception to allow the very thing that the statute seems to preclude, I'm concerned about that.
Justice Jackson, if PLCAA had wanted to preclude any lawsuit against a manufacturer, including for instances where the manufacturer had committed a wrong, it could have done that, as so many different states, in fact, did. What PLCAA did in this effort, which, as I mentioned, was joined by members of both parties, was to carefully carve out circumstances where the manufacturer or the seller was alleged to have done something wrong. The thing they were concerned about was lawful design and manufacture and sale of product and injury solely caused by others. That is replete throughout the purpose section of PLCAA. PLCAA could have been designed quite differently. It was designed this way for a reason, so that harmful actions by manufacturers and sellers breaking the law could continue to be remedied. That was exactly the point.
You've mentioned about 4 times that it was bipartisan. What's the relevance of that to our interpretation?
I think yes, I haven't gotten to 13 times yet, but 4 will do. The fact that it's bipartisan, I think, points out, particularly in this climate, that what was being challenged there were really unusual lawsuits that really weren't showing up in any other part of the economy against the manufacturers of a lawful product, selling their product lawfully, distributing their product lawfully, where no allegations were made in those prior lawsuits about unlawful behavior. That was what PLCAA carefully carved out. What it left, among other things, were actions for things like negligent entrustment, product liability. And product liability is interesting, by the way, because you probably notice this as well. Product liability specifically says you can sue for product liability, but if it was a criminal act, then that act becomes the sole proximate cause. That, of course, is very different from the violation of which is or a proximate cause, which is what you see in the predicate exception. I think that language difference is very important.
Thank you, counsel. I'd like to ask you pretty much the flip side of the question I asked your friend on the other side, which you allege that 2% of the guns manufactured in the United States make their way to Mexico. I assume the volume of that is critical to your argument. And I just want to know how much is enough. If it's 1% or a more minuscule amount, where's the floor?
So 2% is always a question that begs the question of what. And here, what you have is data in the complaint that says, this is paragraph 438, between 342,000 and 597,000 of defendants' guns. And remember, this is not the entire industry we're here talking about. So up to 600,000 of defendants' guns are likely trafficked into Mexico every year. That's your 2%. But I think the issue is not so much whether it's 2 or 10 or 70. It's, do these manufacturers know who the rogue dealers are and what they're doing? And this complaint, in all of those paragraphs that I read to you earlier and many others around them, specifically says these manufacturers know the trace data that show the dealers, that show the bulk sales that are being made to traffickers who come in repeatedly over a short period of time and bring the guns into Mexico where they're found at crime scenes. That, I think, more than percentage is important.
You emphasize you have a number of criteria or examples. You know, the gun says this, or it looks like a military weapon and it has an American flag, and Zapata's.
If you can tell me why an American flag on a gun would be of particular interest to cartel members in Mexico, as opposed to Americans, I'd like to know.
Quote about better to die on your feet than live on your knees. I mean, those are all things that are not illegal in any way. And the idea, there's some people who want the experience of shooting a particular type of gun because they find it more enjoyable than using a BB gun. And I just wonder exactly what the defendant, the manufacturer.
$5. What's my least favorite Supreme Court decision that's audio? That way I can listen in the background over the weekend. Ooh, good question. What is my least favorite that has audio? Well, there was Kansas v. Glover, where I very much disagreed with the majority. That's the first thing that comes to mind. So I disagreed with the majority decision, and ironically agreed with Justice Sotomayor in an 8-1 decision. So that comes to mind as one that might be good. Yeah, let's go with that. Thank you. Chevron might have audio. Yeah, Chevron would have been the 80s. There you go. Chevron versus NRDC. Although it's interesting because the way it was briefed and even the way it was argued didn't really speak to what ultimately happened. So the argument in Chevron was much different than a lot of the ways that the decision ultimately came out. The argument in Chevron was really about what qualifies as a point source of pollution, right? And the decision didn't really solve that issue. It so much as gives discretion to the agency. So the oral argument, it's like and even the briefing really doesn't clue you in to what the decision is going to be. So yeah, listening to Chevron versus NRDC might not be bad, but nothing about the oral argument, at least in my mind, really clues you into why the decision ultimately was bad, because it kind of did something different than what they really were arguing about in a lot of ways. It was a weird case, man. Kilo, yeah, there you go. Kilo versus New London. That's one that's infuriating. There you go. Kilo versus New London. That's a case that'll piss you off. You can listen to that one. That's good.
Manufacturer is supposed to do in that situation? You say no, he shouldn't be marketing a particular legal firearm because they're going to go into Mexico at a higher percentage than others?
Mr. Chief Justice, I think...
By the way, for those of you who haven't noticed, I've put in place a goal in the channel for reading for skimming, or at least reading parts of the complaint. So if you'd like me to read the complaint at the end of the stream, we do have a goal in place. Looking for 9 other people to donate. The reason for that number, by the way, is just to see if there's a broad enough interest, right? If it's just like 1 or 2 people that are interested, if it's not broad enough interest, then, I don't want to bore everyone else. But if there's a broad enough interest, then I'll do it. Plus, other channel creators do goals, and sometimes they're successful. So I figured I'd try a goal and see whether or not we can get success. So if you're interested in that, we have a goal, and I'd appreciate your support. And if we meet it, then we'll do it. That'll be good.
It's not so much that the defendants are designing a particular gun. It's that what the complaint alleges is that they are designing certain guns to target the Mexican market, including the cartels. So if you take the example that you gave, this is paragraph 215. Colt produces 3 models of guns that it specifically targets to the Mexican market: the Super El Jefe, the Super El Grito, and the Emiliano Zapata.
Ooh, the Super El Jefe. The Super El Grito, Emiliano Zapata, 1911. Ooh, the Super El Jefe. Is it because we gave it a Spanish name? Is that what it is? Are you doing a racism right now because we gave it a Spanish name? Thank you for the contributions. We do appreciate it.
1911. These are coveted by the cartels, and you can see evidence of this as paragraphs 217, 218, 219, 220, and they are smuggled into Mexico in volume, which you can also find in the...
Do you know what the percentage of those guns that are sold in the United States compared to the ones that are found in Mexico is?
I don't know, but again, the percentage, I think, is less important than the allegation that they are smuggled into Mexico in volume and coveted by the cartels, including being found on the person of many cartel chiefs who have been arrested.
Thank you. Justice Thomas?
If there's no earlier finding of a violation, how is that done within the context of a civil suit like this?
If there's no earlier finding of a violation, because of course as I think you're getting at, the predicate exception doesn't require one. There's another exception that does. I think what you would find are that at the motion to dismiss stage, the question is simply, has there been a sufficient allegation of aiding and abetting in order to get you past the predicate exception? Now, we talked about how we are here early. There are actually still other motions to dismiss to be addressed.
But it has to be aiding and abetting of something.
Aiding and abetting the violations, including of straw purchasing.
So it is the violation that you say in your complaint there is a violation, but there's been no finding of a violation. How do we know there is a violation?
I think what the district court would determine at summary judgment If the evidence comes back and says, for example, these manufacturers simply had no idea what their distributors were doing or who their guns were going to, or these dealers were doing everything by the book and they are not responsible for the straw purchases that kept coming into their stores. If you had that evidence, then on summary judgment, as has happened before, the court would say, we can't find the predicate exception met here.
So let's say I am the alleged straw purchaser or the retailer who sells to a straw purchaser. Now you have found that I have violated the Gun Control Act, right? And my point is, how do you make that finding within the context of this suit?
Justice Thomas, within the context of that suit, I think you would take discovery from the dealer and ask the question, because remember the predicate exception goes to knowing violation. Ask the dealer what it knew when it sold, for example, as has been alleged in the complaint, dozens of guns over a 2-month period to the same person. The evidence at summary judgment will flush out some of these.
Dozens of guns over a 2-month period to the same person. I'm not sure that necessarily is a clue of anything in particular, but okay. All right.
Questions, but
so you're saying you can find a violation of selling to a straw purchaser within the context of a civil suit against the wholesalers and the manufacturers?
I think maybe where you and I are parting is on the issue of finding a violation. Yeah. We've alleged those violations specifically in the complaint. As far as finding the violation, I think what the district court would do on remand after discovery, if provided we get past the other motions to dismiss that are pending, after discovery would be to ask the question, has the evidence pointed to actual violations? So if you take the Arcadia, California case, that was a case in which at the summary judgment stage, some defendants were dismissed because there was not evidence that they were acting unlawfully. Others were kept in because there was evidence that they were acting unlawfully. So that might be the best example.
Smith & Wesson should just make a not for cartel model instead of the El Jefe. Love it. Love it.
Of the dichotomy you're talking about.
Wouldn't you run into, at some point, a due process problem as far as the people you allege to have violated the Gun Control Act, who have not been charged with that by ATF and proven to have done that by the government?
No, I don't think you run into a due process problem, precisely for the reason I think you pointed out a couple minutes ago, Justice Thomas. There's no requirement of a conviction, and there are plenty of examples, including Williams versus B. Miller from New York, of instances where manufacturers have been alleged to have to have aided and abetted a violation by a dealer, and that case has been allowed to go forward. There's not a due process issue that inheres in that.
Justice Alito?
There are some very interesting technical legal issues in this case, proximate cause, aiding and abetting, how much do you have to plead in a complaint, and you and Mr. Francisco have briefed and argued those very well. It's very helpful to the court. I just thought I would ask you a question that may be on the minds of ordinary Americans who hear this argument or learn about the case. Mexico says that
oh, I love it. Bring it.
U.S. gun manufacturers are contributing to illegal conduct in Mexico. There are Americans who think that Mexican government officials are contributing to a lot of illegal conduct here. So suppose that one of the 50 states sued the government of Mexico for aiding and abetting illegal conduct within the state's borders that causes the state to incur law enforcement costs, public welfare costs, other costs.
Love it. Burn.
Would your client be willing to litigate that case in the courts of the United States?
Justice Alito, I think we would have to accessorize that hypothetical with what I assume are a lot of the things that are built into it, that there are no forum and venue questions, and that the kinds of allegations are specific and talk about specific harms to the state. So
well, would your government say, whoa, your clients say, whoa, sovereign immunity, you can't sue us on this?
Well,
would you be willing to litigate all the doctrines that would apply if the government of Mexico were not entitled to sovereign immunity?
So, Justice Alito, under Pfizer, of course, Mexico is entitled.
I love this argument so much. The state of Texas might be strongly interested in suing Mexico for all the law enforcement costs and all the damages caused by all the illegal immigration that perhaps Mexico has been looking the other way on at best. Yeah, I love it. Let's go.
To come in, and the petitioner's own amici point this out, to come into this case just like any other litigant. There are, of course, differences if Mexico is brought in as a defendant. So I can't and certainly don't feel comfortable giving away things like sovereign immunity on behalf of the government of Mexico.
Well, I understand that. So the argument basically is it's a one-way street.
No, Justice
Alito, the government of
I
Mexico can sue U.S. manufacturers here for harm caused in Mexico, but one of the states here can't sue the government of Mexico.
Bring it, baby. Bring it.
I don't think it's entirely accurate to call it a one-way street, and if the street is one way, it's because Pfizer and other decisions from this court have said that when a sovereign comes into this court as a plaintiff, it is treated exactly like any other plaintiff, no more and no less.
Thank you.
Thank you.
Justice Sotomayor? Justice Kagan? Justice Kavanaugh?
I just want to pick up briefly on questions Justice Thomas was asking. I mean, would your theory of aiding and abetting suggest that manufacturers should be concerned if their products, their lawful products, are sold in certain communities?
I would love it if the gun if the gun manufacturers somehow lose this case and they bring a countersuit against Mexico on the basis that they've already accepted jurisdiction by filing the suit in the first place. It's like, we're going to sue you basically for all the harm you're creating. I'm sure the gun manufacturers could figure out something to figure out how they've been harmed by this. Could be fun. Let's go.
Certain neighborhoods where they're more likely to be misused. You know, we manufacture knives, but there are a lot of.
All right, Brett Kavanaugh is talking about certain neighborhoods now. So Brett Kavanaugh has now given chat cover. God damn it.
Stabbings in certain neighborhoods. We should make sure our products aren't sold there, or a sporting goods company and baseball bats are used to, storm CVS's or what have you. So we shouldn't sell in this city, or prescription drugs are misused in a certain area. So we need to be alert and make sure. Is that where your theory of aiding and abetting leads, that you have to be kind of tracing everything down the chain and make sure we're not selling in these places, or it's not ending up in the places where it's more likely to be misused, or a certain percentage, to go to the Chief Justice's point, are being misused?
Justice Kavanaugh, I think what you've described would qualify under Twitter as general awareness. It would not qualify as specific culpable participation. If you had manufacturer,
you make baseball bats, and they're being used in a particular way in particular areas by particular gangs. And you should. So therefore, we got to make sure that we're not selling to those sporting goods stores that are in particular neighborhoods.
I think that the first lawyerly response.
I'm getting pwned right now by chat via Brett Kavanaugh. Lame.
Response is that guns and drugs tend to be treated differently than things like knives and baseball bats. But even that aside, If you knew that your baseball bats
prescription drugs too.
Prescription drugs were being sold into a particular pharmacy, and this has happened, of course, in the opioid cases, were being sold into a particular pharmacy at, in a small town at numbers that were simply unsustainable, and you knew that you were continuing to sell after being told by the federal government that you were selling into a rogue dealer, and you continued to sell into that dealer, then yes, you would have a problem.
Well, in that hypothetical, they're being told by the federal government. Is that what happened here? They were told by the federal government that these dealers were bad or these distributors were bad? Was that what happened? They were told by the federal government? Is that what happened?
Thank you.
Justice Barrett. Justice Jackson.
But do you concede that you would have a problem or not depending upon how the statute is worded? I mean, we're in a statutory scheme here. We're not just doing aiding and abetting liability as a matter of common law, don't you?
Well, we might not necessarily be doing aiding and abetting as a matter of common law. We might be doing it as a virtue of 18 U.S.C. 2, which is kind of common law, to be quite honest. So okay. Justice Jackson seems to be under the impression for some reason that when the statute talks about violating the law, or even more specifically aiding and abetting, that it has some special meaning in the statute. It's like, okay, in the abstract, that's possible. In the specific though, why? Why are you interpreting aiding and abetting differently in this statute versus any other statute or versus, 18 U.S.C. 2? And it's like, maybe there's a reason, but why? Do you just want to give it your own special, exciting interpretation because reasons? It sounds like you want to give it your own exciting interpretation because reasons. I'm not here for that. I'm not here for because reasons. Why do you think this should be interpreted differently than the normal understanding of aiding and abetting? What's the rationale? I don't know.
Agree?
I do agree with that, Justice Jackson, but I think the fact that we're in a statutory scheme is an important element of centering this case where it is now. That's why I said earlier we are at the beginning of this case.
I understand. I guess just quickly in response to what Justice Kavanaugh was just exploring with you. The facts that he laid out seem to me to be covered by this particular PLCAA immunity. That Congress looked at that situation and said, the term qualified civil liability action, which you can't bring in court, means a civil action resulting from the criminal or unlawful misuse of a qualified product by the person of a third party. So in other words, Congress started with Justice Kavanaugh's example. My product is being used by third parties in criminal ways, and they said immunity. So to read the exception to that as essentially capturing the same facts, if you know that your product is going to these people, seems odd to me.
Yeah, for the criminality of the third party, right. For the criminality of the third party. But I can't believe I'm about to disagree with Justice Jackson in a way that arguably harms gun owners or something. But that's, yeah, she seems to be under the idea that, okay, the whole point, or at least a significant point, was to prevent liability for the criminal actions of third parties. And then she says, well, you're reading the predicate exception to include that. But arguably she's not doing that, right? We're not talking about the criminal actions of a third party. At least she's not talking about the criminal actions of a third party. So we're talking about the hypothetical criminal actions of Smith & Wesson and others who aided and abetted or whatever it is they did. That would be their criminal exposure. So she seems to think, well, she seems to think you're using the very thing that's the exception to make the predication. And I'm like, no, she's not. This would be Smith & Wesson's responsibility for the aiding and abetting that would defeat their liability. or their liability shield. So I am now disagreeing with Justice Jackson in a way that creates more liability for Smith & Wesson. And I don't like that feeling. I don't like that feeling. But that's where I'm at. I mean, you still have to prove the aiding and abetting by Smith & Wesson, which at this moment you're nowhere close to. But like, if you can, then yeah, it would defeat their protection. I don't understand how Justice Jackson's reading this statute. It's very, very confusing to me. I don't get it.
Justice Jackson, what Congress said was immunity unless. And the predicate exception that we've been talking about says immunity unless the manufacturer is alleged, among other things, to have aided and abetted violations of federal gun laws.
Thank you.
That's the important point.
Thank you, counsel.
Thank you.
Rebuttal, Mr. Francesco.
Thank you, Mr. Chief Justice. Just a few points. First, Justice Thomas, as to one of your questions, if they're right under PLCAA, this would in fact revive the exact same lawsuits that PLCAA was meant to prohibit.
Well, no, I don't think so. If I'm understanding Mexico's argument correctly, and what they believe is correct, no, it would not revive the lawsuits under PLCAA. Because, well, now we could get still into issues of proximate cause, which is a separate concern, but we wouldn't be holding you responsible for the third parties, although maybe that's an intervening cause or maybe something, but like we'd be holding you responsible for your actions that were criminal that led to, stuff and things. So I don't think it would revive the lawsuits that PLCAA was meant to prevent. If I understand Mexico's theory of the case. So I don't think I agree with that. I mean, this is all, of course, assuming that Smith & Wesson is aiding and abetting in at least a knowing, if not purposeful way, with intent, at least knowingly, aiding and abetting these illicit gun sales. And then we could get into whether or not proximate cause, and then we could get into whether or not the criminal behavior, someone else somehow breaks the chain of causation. But we can get past step one. Wouldn't conspiracy make more sense? Maybe. Thank you, Lois Thomas, for the 5 gift memberships. It's appreciated.
If you look at Mexico's complaint, the underlying torts alleged, which is what they're seeking relief on, are the exact same torts that were at issue in all of the other cases. The violations only come in their effort to get around PLCAA and fit with one of its exceptions. But if you accept their interpretation of the PLCAA exception, you will have revived exactly the same type of lawsuit that PLCAA was meant to prohibit when they adopted the statute in the first place.
I don't think that's correct. Not if I'm understanding Mexico's theory of the thing, and maybe we can go read their complaint, but that doesn't sound right. Right? We're not holding you responsible for the third party behavior. We're holding you responsible for your own behavior, which might have led to the third party behavior, but you still have a direct criminal responsibility in the first instance, right? So like, again, right? It's not that you sold a lawful gun, a criminal did something bad with it. You're responsible because the guns are dangerous. It's like, no, the guns did exactly what they're supposed to do. I didn't do anything wrong. I sold a product that works exactly the way it's supposed to in lawful commerce. And the bad guy did something with it. Well, that's the bad guy's responsibility. Why is it my fault? Right. That makes sense to me. But Mexico's theory of it is, no, wait a second. Now I'm aiding and abetting directly with knowledge and possibly intent, aiding and abetting these illicit sales with knowledge that the criminal is going to do something with it. That's not quite the same thing. If I understand Mexico's theory of the case, and then of course, whether or not they're able to provide enough information to allow that go forward is a whole nother set of problems. But I don't think it revives the lawsuits that PLCAA was meant to prevent. Not the way I understood their framing of it. Maybe their complaint does something different than what they framed it out as. Maybe that's true, but I don't know.
Secondly, my friend talked about some paragraphs in their complaint.
Also, I feel aiding and abetting has to be an affirmative action. Like, I don't think letting an illegal immigrant into church is aiding and abetting, but hiding them would be. Yeah, I mean, you have to provide them some sort of basically like, in long or short, you have to basically facilitate them in some way or further their crime in some way. You have to yeah, basically, yeah, like if I just let you into church, it's like I haven't done anything. It's like, yeah, the hiding would be like, yeah, that's right. So I have to facilitate or augment or further your crime in some way. That's right. No one is saying that Smith & Wesson is selling directly to Mexico. That's not the thing. No one's claiming that.
But I think that their complaint makes quite clear what their basic...
Or directly in Mexico. They're not saying that either.
Aiding and abetting theory is. Paragraph 228, and this is an allegation that they repeat throughout. Each defendant's policy is to sell its guns to any and all federal firearms licensees. That is anyone that the federal government says that we can sell to. So their allegation is that we're treating all retailers exactly the same. We're not treating any one better than any other. We're treating them the same. That's important because in Twitter, the court made quite clear that the reason they didn't get across the aiding and abetting line was because there was no allegation that they were treating ISIS, who they knew to a metaphysical certainty was on their platform. They weren't treating ISIS any better or worse than any other customer. Instead, they go on, and this is paragraph 110, to explain their theory. A manufacturer of a dangerous product is an accessory or co-conspirator to illicit conduct by downstream actors where it continues to supply, support, or assist the downstream parties and has knowledge, actual or constructive, of the illicit conduct. I think that's the mere knowledge theory that my friend was just referring to, Justice Kavanaugh. That, however, is the theory that the court squarely rejected in the Twitter case. Turning to foreseeability, Mr. Chief Justice, there was an exchange with my friend on the case law where I think what I heard her say was that an intervening independent act didn't break the chain if it was foreseeable. Well, I would say that that is completely inconsistent with this court's repeated statement that foreseeability alone isn't the standard. It's also completely independent with the Hemi Group case that did not involve a derivative injury. New York City was the only plaintiff that could sue for the lost taxes that New York City suffered. There was absolutely no other plaintiff that would have been able to pursue that remedy and that loss. Yet this court held that the intervening independent act did break the chain. Lexmark is no different. It did not involve an intervening independent act. If I trick consumers into not buying my competitor's products, I've directly harmed my competitor. There is no intervening independent act. As to the various treaties, I would agree, Justice Sotomayor, with your suggestion that the law and the verbal formulations here are kind of a mess. But if you actually look at the cases that the treatises cite for their assertion that foreseeability alone is the standard, they don't cite this court's cases, which is kind of surprising if what they're supposed to be doing is describing the law rather than making the law. But the cases that they do cite principally involve special relationships, like a landlord-tenant relationship or a teacher-student relationship. They don't cite any case in which a manufacturer has been held liable because some criminal unlawfully misuses its product to harm somebody else. My friend again emphasized the Washington Post article. I would urge you to read that article from beginning to end. I think it's very helpful in illuminating how even their theory of mere knowledge doesn't make sense. My friend also talked about 3 pistols sold by Colt with Spanish-named firearms. The notion that selling a Spanish-named firearm is what gives rise to joint purpose with cartels under the aiding and abetting statute is as wrong as it is offensive.
Yeah, preach it. That's a dumb argument.
Millions of perfectly law-abiding Spanish-speaking Americans in this country that find those firearms very attractive, and making those firearms available cannot possibly cross the line into aiding and abetting liability. But even if it could, the notion that selling 3 Spanish-named pistols is the proximate cause of cartel violence in Mexico.
I think we're going to have to do better than we sold something called a Super El Jefe. I think we have to do better than that.
Plausibility standard. My final point is just to step back and talk about what PLCAA was really about. At the end of the day, PLCAA is about protecting Second Amendment rights. It's not just about protecting the manufacturers, the distributors, and the retailers, but it's protecting the right of every American to exercise their right under the Second Amendment to possess and bear firearms. That right is meaningless if there are no manufacturers, retailers, and distributors that provide them in the first place. We ask that you reverse.
Thank you, counsel. The case is submitted.
All right, guys. So I see that you guys donated a little bit after the clock, but that's okay. I'm not going to hold it against you. You came close enough, so we'll do the thing. I need to take a break, though, for just a minute because I need to use the facilities because I've been streaming for 3 hours and, nature calls and all the rest of it. But, we will read at least portions of this. And where did they start? Like at paragraph 140 they talked about, and then they went on to like 290, something like that. So like maybe we can sort of skim paragraphs 140 to like 290-ish and kind of go that. I'm not going to read every word, but I will like skim it because I can read faster than I can recite it back. Yeah, 140 to 205. Yeah, well, let's do like 140 to 205. That sounds plausible. And we'll see whether or not anything there makes any sense. 122. We can go to 122. We're just going to skim it. If I don't read every word, I can do it a lot faster. If I read and I only comment when I have to, I can read a lot faster. So we'll do that. And we'll see what they have to say. All right, so I'm going to leave you with B-Fish for a moment while I quickly use the restroom. So B-Fish will keep you company. B-Fish has some pretty good jokes, by the way. They've been working on their material recently. They're thinking about doing a stand-up act. So if you're good, B-Fish might tell you some jokes. I'll be right back. Okay. Let's take a look. Take a look in a book, reading Rainbow. friends to know, way to go, reading Rainbow. All right, let's see what we got. Come on, mouse. All right, let's see what we got. All right, so let's pick it up. Let's pick it up here at 115, I guess. Defendants are on full notice their conduct causes unlawful trafficking. Okay. Some dealers sell their guns at retail. They know. How do they know that? It is well known that majority sell zero crimes guns, while a small minority, fewer than 10, sell 90%. Defendants know about a fairly small percentage of dealers. Public reports and articles have identified the dealers. Washington Post identified named by 12 dealers that sold the most guns recovered in Mexico in 2010. In 2010. But did the ATF take any steps? Did they shut them down? I mean, what's going on, right? So like the Washington Post seems to think some things, but it's like in no time in the subsequent years did they shut them down or what? Okay, that seems odd. Defendants regularly receive even more direct information, trace requests from ATF and other agencies alert defendant that guns they sell to specific dealers and distributors are recovering at crime scenes. Industry participants know a high volume of crime crate charges is a trafficking indicator. Defendants can get trace data from ATF and can require their dealers to forward all trace requests to them. Defendants choose to remain willfully blind. No, that's not the same thing as willful blindness. No. This is in the complaint. This is in the original lawsuit, not the cert. We went all the way back to the complaint. Defendants know that ATF alone, without defendants' own monitoring, can barely make a start on preventing gun trafficking to Mexico. Why? If it's a small number of dealers, then why can the ATF not stop it? Because it's just a small number of dealers. So they have a target environment, man. The Department of Inspector General found the ATF only inspects 11,000 of 135,000, 10% of all licenses. Well, and ATF has not implemented a mechanism to track and prioritize for inspection it considers to be high risk. Okay. Even in cases where ATF inspects a dealer, licenses are recently revoked. Sounds like you have a complaint with the ATF to me. Illinois retail dealer was allowed to stay in business after receiving 2 warnings following inspections. There's really no teeth in the law. This is not meant to criticize the ATF. Are you sure? I feel like it is. Even without trace information from law enforcement, defendants are aware they're routinely supplying gun traffic to Mexico. The problem of gun trafficking has been documented in more than 3,000 news articles in the U.S., more than 100 academic studies, and a multitude of governmental reports. Uh-huh. 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 Defendants demonstrated their awareness of the problem by fighting U.S. federal efforts to address it. They have a right. They have a right to petition their government just like everyone else does. Retail customers buying multiple guns may be trafficking, so U.S. requires dealers to timely inform mobile sales of handguns, but doesn't apply to long guns. The gun industry tried to keep information from law enforcement and enabling the traffic to continue. Well, maybe they're just not really thrilled about the Second Amendment being regulated. It could be that. Continue to use unmonitored and undisciplined distribution systems to supply military-grade assault weapons in the U.S. Okay. Authorities repeatedly identified the use of guns in notorious gun trafficking rings. Gun dealers sold to traffickers 37,200 rounds of ammunition. Wow. That is. Wow. Okay. So from March 2016 to December 2018, gun dealers sold to a trafficker 37,200 rounds of ammo. Over the course of 2.5 years. Sounds like my weekend. You know what I'm saying, man? Damn. They sold 37 rounds, man, over 2.5 years, man. Okay. And they sold 3 handguns. Ooh, that's exciting. He then smuggled it in Mexico during 87 border crossings. Okay. Did they know about that at the time they sold it? Okay. Gun dealer sold another trafficker assault rifles that are coveted by criminals and drug organizations. Okay. In 2007 and 2008, a Phoenix gun shop called Excalibur Guns sold more than 650 guns, mostly assault weapons, including AK-47s, to straw purchasers produced by gun cartel. Okay, did Excalibur know about that? Did Smith and Wesson? Excalibur sold the guns even after being told the purchasers planned to sell them in Mexico. Wait a second, 2007 to 2008? Isn't that when Fast and Furious was happening? Or is my timeline off? Isn't that when Fast and Furious was happening? So, didn't the government tell them to do that? 2012? 2003? It can't be both those things. Yeah, okay. Several crime guns recovered in Mexico are traced back to Excalibur, including some other stuff. Yeah, when did Fast and Furious happen? Hold on. Fast and Furious scandal. Hold on. We need. Yeah, I thought so. Yeah, a tactic used by by Arizona's ATF, which ran sting operations between 2006 and 2011. Yep. So the Arizona's attorney's office, and here we've got a Phoenix gun shop. Yeah, remind me what state Phoenix is in again? Oh, that's right. Oh, that's right. Oh, that's right. Okay. Lord. Ballistic guns conspire with the Tucson. Oh, Tucson police officer. You remind me what state Tucson's in again? I'm so confused. All right, now we've got a Texas dealer finally. That's nice. From January to November 2003, a Texas dealer sold more than 150 guns to another gun trafficking gun in Mexico. Okay. Yeah, all right. I mean, how did Smith & Wesson know about these things? From 2006, a dealer in Spring, Texas supplied a trafficker with 2 Smith & Wesson rifles. I'm not sure that you can really infer anything from they sold a guy 2 rifles. Did they know he was a trafficker? Did Smith & Wesson know? I have problems relating to this. From 2007 to 2018, dealers sold 25 guns to a trafficker for a man known only as her El Mano. Okay. All right. So we've got some more instances with, guns being sold that wind up in Mexico with some various straw alarms. 10 gun dealers in Houston sold 336, again, 2006, 2007. Yeah, when was Fast and Furious again? Oh, yeah. Sold a gun, Sun guns to 10 straw purchasers. Straw sales of more than 100 assault weapons and other weapons include 26 pistols, 4 pistols, and 3 Century Arms rifles. Okay. MG Law. I'm not really connecting the dots in a major way here. It seems like you've got some scattered things of some scattered people with winding up in Mexico. I'm not quite sure to how you get to exactly how you get to Smith & Wesson knew and was aiding and abetting with intent and stuff. I'm not quite sure how you get to that from this, but is it just me? I'm not really super sold right now. It feels a little tangential for my taste. Okay. In 2018, in Armory, a Houston dealer sold a traffic ring's primary buyers more than 170 guns, including 76 AK rifles, 86 AR rifles, and 650 caliber rifles, at least 2 of which were Barretts. Okay. Did he know that they were a trafficker? Did he know that? Did Smith & Wesson know that? Did they fill out all the paperwork? Did they fill out all the forms and so forth and so on? Did they know that they were selling to a trafficker? Or you just think that because he's buying a lot of guns, they should just assume he's a trafficker? That's interesting. A former employee of Academy Sports and Outdoors claimed his supervisor told him to create a fake gun transaction record. Okay. He asserts that he was wrongfully testimony when he refused. Okay. Reports have identified Academy as one of 12 top dealers selling the most crime guns recovered in Mexico. Again, I'm sort of back to like if it's true that that it's a lopsided thing, which makes sense, like basic Pareto distribution, right? 20% of the dealers are responsible for 80% of the problem. Yeah, basic Pareto distribution. So like, okay, if that's true, then Can't the ATF like do something about that with respect to those dealers because, you know, they know who they are or could figure that out rapidly? You know, that's okay. In 2006, a Dallas trafficker was convicted of buying more than 100 assault weapons from U.S. gun dealers over several months. Okay. Did they then continue to sell him weapons after that? Did Smith & Wesson know? In 2011, 2 other traffickers were sentenced for recruiting straw purchasers to buy approximately 40 guns, particularly Colt's El Grito super pistols, which have gold engravings and commemorate Mexican independence. Cool. (2006 to 2009), another trafficker masterminded the arming of La Familia. Okay. Did Smith & Wesson know that? Colt also is not Smith & Wesson. That's true. But because they knew about it for Colt, they should have been suspicious and stuff. I mean, you know, just don't worry about that. That's those details don't matter. Don't worry about it. It's fine. Note at the outset of this complaint, the Boston area has more than its fair share of distributors and dealers whose guns have been traced to crime scenes. But I thought you said earlier it was because of all the gun dealers that set up shop on the border. I remember you saying that earlier in the complaint. I remember you saying earlier in the complaint it was all those gun shops that set up their operation right on the border. Okay. Is Boston on the border with Mexico? Did it move? Where's Boston again? Is it in South Texas? Is it near El Paso? I'm confused. I thought I understood geography, but you know, now I'm not so sure. Okay. Unless we have a very loose definition of near the border with Mexico. So I suppose within certain loose definitions, then sure, Boston is near the border with Mexico. Let's go with that. That sounds good. There is a Boston, Texas. I don't think that's what they're talking about, though. Could be wrong, though. Kentucky, man. Also, Kentucky may also be on the border with Mexico. Yeah, Kentucky shares a border with Mexico now. That's fun. What else we got going on? Suburban Illinois. If Illinois is on the border with Mexico, then we've got to have a conversation. Apparently Illinois is on the border with Mexico. Apparently the United States has been conquered while I haven't been paying attention. I guess I got to brush up on my Spanish, since apparently I'm now a Mexican national. This is distressing news to me. I guess I gotta start all over again. I've got to go to a Mexican law school and I've got to learn about Mexican law, man. I got to start all over again. This is very distressing to me. And I got to learn how to speak Spanish. This channel is changing with every passing moment. Traffickers bought gun from Nevada. Well, Nevada's closer. Alabama. Yeah. Como si dice chat is stupid en español? That is a very good question. Yeah. That is something I need to know the answer for. How do you say chat is stupid in Spanish? That is important information. Let us find out. All right. Translate English to Spanish. Okay. chat is okay. Wait. All right. Chat, but I don't think that Charla. That sounds like chat the verb rather than the noun. If I had to guess. Wait, I could say the gallery maybe, or what would be an unambiguous word that would refer to a group of people that are like watching the audience. Yeah, the audience. The audience is stupid. El público es estúpido. Estupido. El público es estúpido. There you go. That sounds good. Let's go with that. I'll work on my pronunciation. It needs help. Chat as stupido. Yeah, sometimes. Each of these and other traffickers are supplied by dealers. The defendant chose to sell their guns at retail without any monitoring or standard to ensure they're selling guns legally and responsibly. Well, no, I mean, presumably they were following all the law that they were supposed to do. If the defendants used reasonable care or chose to fully comply with and enforce the law, they didn't fully comply with the law. Which law did they break? Defendants chose what to use when their guns are sold at retail, such as employing screening to prevent straw sales. Not limiting sales, that's not required. Not limiting repeat sales, not required. Not screening before selling military weapons, not required. And not posing any discipline or sanctions after violations are established. By whom? Under direct sales, defendant knowingly violated the laws of Mexico. Okay. Notorious violent incidents give defendant continual notice their guns are trafficked into Mexico. The media drew it plainly for them in an easy-to-read graphic. Okay. Here is a picture of a car that's been shot by guns. Something Smith & Wesson. I have my doubts. In 2016, gunmen apparently linked to the Knight Templar cartel. The Knights Templar enter the chat. They shot down a helicopter belonging to the state attorney general office using a 50 caliber rifle. Okay. Oh, defendant Colt is also being sued as part of this complaint, along with Smith & Wesson, by the way. So yeah, fair enough. So Colt is also being sued. It's not just Smith & Wesson; it's a bunch of people. Who is being sued in this thing? Who do we sue? Smith & Wesson, Beretta, Century Arms, Colt, Glock, Sturm Ruger, Interstate Arms. Okay, we sued a lot of people. More than 2,000 assault weapons between 2006 and 2018 were produced and distributed by Colt, more than any other manufacturer. Colt does not even try to hide his pandering to the criminal market. Colt produces 3 models of guns. It specifically targets to the Mexican market. These are the 38 caliber Super El Jefe pistol, the 38. I mean, I'm not. The cartels use 38s. I mean, it doesn't sound like the most cartel thing I've ever heard in my life. The 38 caliber Super El Jefe pistol, the 38 caliber Super El Grito pistol, and the 38 caliber Emmanuel Zapata's 1911 pistol. These models are status symbols and coveted by drug cartels. Okay. Colt Special Edition .38 super pistol is engraved with an image of a Mexican revolutionary, Emilio Zapata, on one side of the barrel, and a phrase attributed to him on the other side: "It's better die standing than live on your knees." Okay. Here apparently is a picture of the scary, scary pistol that apparently only a Mexican drug cartel would use, I guess. Iano Guerrilla, author of Blood Gun Money, How American Armed Gangs and Cartels, wrote, "It was a cruel irony. An American gun embellished with an image of a Mexican free fighter was used to silence Mexico's freedom of speech." This is a photo of that gun. Okay. The Gulf Cartel's Jose Luis Zunga Harenda El Huicho was arrested. Authorities seized from him a gold-plated, diamond and ruby encrusted .38 super handgun they paid $57,000 to have custom made. So I guess what Colt was selling wasn't good enough for him. So Colt's attempt to pander to the cartels apparently is not successful, because this guy was not having it, because apparently Colt does not make a factory-made, gold-plated, diamond and ruby encrusted Colt .38 super handgun. Colt is letting part of the market slip them by. Colt is letting part of the market in their attempt to get to the cartels. They're not making the ruby diamond encrusted .38 super handgun. Colt needs to try harder. You're letting the market slip you by, Colt. Defendant Ruger's weapons have likewise figured in notorious instance. Inagio Nachicho Villabolas was a member of La Lina, the enforcement wing of the Juarez drug cartel. They cooperated as co-conspirators in purchasing 400 guns to be smuggled into Mexico. This included nearly 200 AK-47 type pistols, at least 4 Ruger 45 caliber pistols. 2 of these pistols were later recovered, one at the murder scene of a Mexican state of Chihuahua. Okay. Other high-profile incidents gave further notice to all manufacturer defendants their guns are routinely trafficked into Mexico and used in violent episodes. Yeah, but if they didn't know specifically which dealers or what, it's like, and you're not really getting me to where I need to be. Yo tanto pero no puedo decir inteligente. Yeah, about that. Yeah. In an interview, one Mexican man involved in the violence pointed to words stamped on the barrel of a Colt match trigger assault rifle slung across the chest of a teenage fighter. Hartford, Connecticut, and told reporter, "We kill each other and you send the bullets." The Mexicans are killing each other at record rates. The U.S. provides the guns. Uh-huh. Okay. Despite this voluminous notice, defendants did not institute a single public safety protocol in their systems to detect and deter gun trafficking. Each defendant's policy is to sell its guns to any and all federal firearms licensees, anyone with a permit. The only other restrictions they put are financial. Defendants have not implemented any public safety requirements designed to safeguard the lives of nationals. So they're selling to licensed distributors. Are you sure you're not criticizing the ATF? It sounds like you might be criticizing the ATF. Defendants know that material-style weapons such as assault rifles and sniper rifles are particularly sought after by drug cartels who use the devastating effect in Mexico. In 2009, the House of Representatives held a hearing. Testimony provided during the hearing established analysis of aggregate crime data can reveal trafficking trends and networks. Defendants have long had access to this trace data and other information, including specific networks as distributors. But they weren't provided it. They could have gotten it, I suppose, but they weren't gotten it, right? I mean, it sounds a lot like an ATF problem. It sounds a lot like the ATF should be saying, hey, by the way, we're concerned about some of this stuff, and, this could be a problem maybe. So it sounds like the ATF could have sent at least an email. That would have been good. Defendants actively assist and facilitate trafficking. For many years, defendants have sold tens of thousands of guns that have been obtained by unauthorized and irresponsible persons in Mexico through straw purchasing. Many of these purchases have occurred in circumstances that clearly indicated to the gun dealer the transaction was a straw purchase. Even if that's true, how did it indicate it to the gun manufacturer? These purchases would not have been made. Defendants require their dealers to be well trained and committed to following the law. Again, what law did they violate? As a result, unauthorized and irresponsible persons, including convicted felons, have obtained thousands of guns from these sources. Straw purchasing is the most common method of trafficking guns. Illegal diversion through straw purchasing has been common knowledge in the industry and known by defendants. Yeah, but in general, yes, I'm sure. But what are they supposed to do about it exactly? Defendants could sharply limit sales by regulating their own distribution system through prudent practices. 4 principal ways to stop trafficking would be limiting the sales of multiple guns, mandatory background checks for secondary gun sales, curbs on straw purchasers, like what, and restrictions on assault weapon sales. Oh, so you don't want us to sell certain kinds of guns. Oh, so you don't want us to sell guns that are scary. And incidentally, by the way, the gun dealer is required to do a mandatory background check for secondary gun sales. Gun dealers are required to do background checks for all gun sales. So you say you want mandatory background checks for secondary market. If they're going through a licensed dealer, they do. They do go through a background check. And if they're not going through a licensed dealer, how could Smith & Wesson prevent it? Right? Even if Smith & Wesson wanted to, how could they prevent it? By calling for legislation that requires secondary checks for all firearm sales? I mean, that's the only way to do it. And even then, some would be illegally stolen, but what do you want us to do exactly? Yeah, the dealer already does a background check. Exactly. Of course they do. It's required. Yeah, I know they do. Yeah, in New York, in my state, we don't have background checks for person-to-person sales. That's what I'm saying. Right, exactly. So that's exactly what I'm saying, right? If it's a person-to-person sale, that's true. So it's okay, if it's an FFL to person, there is a check. If it's person-to-person, there's not a background check. But how would Smith & Wesson or any other gun company mandate background checks for secondary gun sales? How would they do that? Right? Because they say defendants could sharply limit sales by regulating their own distribution. Okay, how can they regulate their own distribution in a way that would produce mandatory background checks for secondary gun sales? How would they do that? How would they do that? How would they change their own distribution system in a way that would require mandatory background checks for all secondary sales? How would they do that? Anyone know? I don't know. I don't know how you do that. I mean, yeah, you would the only way to do that would be to call for legislation that would require private to private sales to go through background checks. That would be the only way to do that. So you want Smith & Wesson to lobby, I suppose, for legislation requiring mandatory secondary checks for all guns, regardless of whether they're private or not. So that's the only way to do that. They can't do it by changing their own distribution, though. They can't do it by changing their own distribution. Defendants do not need legislation in order to make these reforms. They could do it themselves. How? How could they do that themselves? How could they possibly do that themselves? Anyone have any ideas? Without legislation? How could Smith & Wesson, if they wanted to, require mandatory background checks for all secondary gun sales? How could they do that? Anyone have any ideas? I don't know how they could do that. I don't know how they could do that even if they want to. Yeah, they can't. I don't know how they could possibly do that. I don't get it. Write it into contracts? That doesn't work because the contract would only apply to the first seller, and they have to do it anyway. So, yeah, that doesn't work because the contract wouldn't bind the subsequent party because they're not a party to the contract. It doesn't make sense. Yeah. The first seller can be required to contract the subsequent party to complete a sale. You're talking about limitations on the moving of personal property. That's kind of not really strongly favored in law, generally speaking. So I guess maybe you could try to do that, but I'm not sure how you would enforce that. That doesn't make, I don't know how you would enforce it. So yeah, you might be able to try to do that, but some states won't let you do it anyway. And I don't know. Yeah, it's kind of weird. Yeah. Okay. You're no expert. No, you're cool, Nicholas. You're cool. Yeah. It's disfavored. Something in the UCC, I think, about this. Actions on sales. Okay, yeah, it's like contract restrictions on resale. Maybe something. Yeah, you can kind of do it in business to business a little bit. Seller resale, including contract for resale. This is what I'm looking for. Two, 7. Yeah. It might be possible, but it's not really favored, and some states won't allow for it anyway. But let's press on because my brain hurts trying to find out how we could do this. Defendant's failure to curb straw purchase bound for Mexico also encouraged violation of specific strictures on straw purchases. The straw purchaser fraudulently certifies a form. The dealer then separately falsely certifies the sale is lawful. How do you know that they know that with knowing? A licensed dealer that falsely certifies sales is lawful despite knowing they falsely yeah, if they knew about it, that's true. If they knew. More Karen Reed action. What else is going on in Karen Reed action today? What else is going on? Tony, help me out. What else is going on in Karen Reed land? I don't see anything. Oh, it's in staff chat probably. I'm on the wrong channel. Wow, they imposed a gag order. Wow. Wow. We need a separate Karen Reed stream. We need a separate Karen Reed stream. It may not be a long stream, but we need a separate stream. A gag order on who? The defense lawyers. Is it specifically the defense lawyers? Hold on. No, it's none of the lawyers. Okay. So it's a gag order on the lawyers. Despite the fact that he never made a statement extrajudicially in the first place anyway. Wow. Also denied a motion for sanctions. Yeah, can you get me copies of all these documents, Tony, please? I see that there's some of them here. Can you give me all these documents? I'd appreciate it. Just give me all the Karen Reed stuff. Preferably if you can find like the full PDF would be nice. I'll take just pictures or PDFs if that's all they got. But if you could find me the original PDFs, that'd be nice, if possible. Lord. Let's see. Defendants actively assist and facilitate through mobile sales. Defendants regularly allow guns to be sold to dealers as part of our multiple purchases. Congress and ATF have warned making large volume sales is a high-risk practice. Defendants actively assist and facilitate trafficking through kitchen table sales. Exciting. Defendants have sold thousands of guns to so-called kitchen table dealers, licensed dealers that do not sell guns from a retail store. Okay, these dealers sell guns from their home or unlawfully from parking lots. I don't know the finer points of the law or out-of-state gun shows and do not invest in inventory tracking. Well, I mean, they're okay. They operate a virtual an online presence. Okay. Ruger dealer asked it to stop supplying non-storefront dealers. Actively facilitate trafficking through missing guns. In the U.S., a gun is stolen every 2 minutes. Dealers also lose guns. Unscrupulous dealers chose not to implement simple anti-theft measures because their absence enables the dealer to falsely claim the guns that are unaccounted for were stolen when actually they're sold off the books. That's one hell of a conjecture. Defendants actively assist and facilitate trafficking through gun shows. That's neat. We don't like gun shows anymore. Gun shows are a significant source of guns for criminals who in turn traffic these guns directly. Gun show sales by non-licensed sellers to private citizens constitutes a loophole to be sold without a background check. Defendants are fully aware of this loophole. Although a licensed dealer selling a gun show must comply with the same regulations as anywhere else, sellers of a gun show are known to sometimes evade or violate laws. ATF officials have found gun shows are a source of sizable numbers of guns smuggled into Mexico. Gun show cowboy dealers purchase large quantities of guns from distributors and then resell them at gun shows on a cash and carry basis. They accompany this by pretending to be an unlicensed seller who is not subject to the background check requirements and other legal rules that apply to licensed dealers. Lol. Defendants actively assist and facilitate trafficking by designing and marking their rifles as military assault rifle weapons. They sell guns we don't like. Defendants design their assault rifles so they accept large capacity ammunition magazines. Well, as long as the magazine is detachable, that means that you can have a large capacity magazine. Right? The only way to not do that would be to have an integrated magazine. But if it's detachable, then you can have as big a magazine as you want because you can just plug it into the thing. So I guess we oppose any gun that has a detachable magazine, or at least a non-integrated one. As defendants know, there are several readily available ways for assault weapons to achieve even greater rate of fire. Some of these include a gat crank bolted to the AR-15 trigger well, which allows the shooter to fire multiple shots with each turn of the crank, a bump stock, hellfire triggers, pull and release triggers, and bump firing. An AR-15 can be modified by drilling a few holes and winding the inside of its frame to accept the sear. Defendant calibers, okay. For example, cartels have used Barrett rifles to shoot down helicopters. Under the plain language of the law, it's illegal to assemble any semi-automatic rifle that incorporates any foreign-made parts and includes features rendering it not suitable for sporting purposes. Century Arms violates this by supplying rifles to the public after modifying them in accordance with their scheme. Okay. But then there's a different law that says sporting purposes does not apply if the complete gun has 10 or fewer imported parts. So, okay. You just sound salty. They market their guns as military assault weapons. Well, who cares? We're going back to marketing. We're trying to do the Sandy Hook thing again. Oh, here are some scary, scary ads, people. Shield your eyes. Shield your eyes. Here's some scary, scary gun ads. Smith & Wesson, the chosen one. Tested, proven, selected. M&P, the line of duty. Smith & Wesson, 22 caliber. M&P, 1522. Kick brass. Pure adrenaline from Smith & Wesson. The authentic military and police 22 long rifle design. I'm sure that's what the cartels are using, the 22 long rifle. Defendant Colt markets civilian products as military weapons. Okay. It markets civilian assault rifle as a trooper and trots another that shares many features of its combat-proven brother. Okay. Here's some more scary, scary ads. Here's one from Barrett. We've created a monster. Here's some pictures. Here's a picture of a scary gun. Defendants know their military-style weapons are the cartel weapon of choice. I'm not feeling this complaint, guys. I'm not feeling this complaint. The reckless marketing of weapons is unlawful. Reckless marketing. Reckless marketing. That's fun. That's a fun one. We've recklessly marketed. Okay. All right. Recklessly marketing. Is recklessly marketing not protected by the First Amendment? I don't remember that exception. Could anyone cite that case, please? That'd be great. By way of example, Smith & Wesson violated Massachusetts Consumer Protection Act through marketing that emphasized the ability of civilians to misuse assault rifles in unlawful military-style attacks and encourage such use? What? When did they do that? For example, Smith & Wesson uploaded on its YouTube channel a video endorsement of its M&P 15T model rifle from a professional shooter who described it using the world weapon to establish a world record in speed shooting involving 10 shots fired in 4 different targets in 1.59 seconds. Okay. Smith & Wesson emphasized it lets you kick brass by burning through all ammunition you want. Uh-huh. Okay. Defendants as actively assist and facilitate trafficking by designing their guns to allow to be used by unauthorized persons. Defendants magnify the dangers by designing guns that are easily transferable to the criminal market. They could use safety features. Defendants' guns are defective and unreasonably dangerous, and among other things, they enable any person who gains access to fire them. Okay. Technology for safety features that permits only authorized users to operate a gun has long been available to defendants. One manufacturer, Taurus, began selling handguns with integral locks in 1997. As touted by the manufacturer, the system is for those concerns about unauthorized use and renders guns inoperable by use of special key. Yeah, I'm sure the Mexicans could not get the special key. Defendants could have also developed and utilized sophisticated safety features that employ biometric, radio frequency, or magnetic technologies. Inventors have created such devices since the 70s. Not in any sort of reliable way, they haven't. A 17-year-old from Boulder developed a smart handgun that fires only when fingers recognize the grip. Yeah, about that. You need the gun to be able to work when, your life is on the line. You need the gun to be able to fire when your life is on the line. And the problem with a lot of these technologies is they work sometimes, and then sometimes they fail. Because a gun, as you may or may not be able to appreciate, is, encounters a lot of vibration and there's a lot of force involved with the bullet going that way and the slide coming back this way and a lot of other things. So can you develop a technology that works once? Sure. Can you develop a technology that works for the entire life of the firearm? That's a lot more challenging. And that's a lot more challenging. There's a reason that cops don't have guns with these safety features on them. They could. Why don't they? Because they need the thing to go bang when they pull the trigger. And you can develop technology that will work once. It might work 100 times. It might work 1,000 times. Trying to get it to work reliably throughout the life of the gun is a much more significant problem. Plus, also, by the way, those parts can be swapped out because, if you integrate it, you can swap it out or disconnect it or a lot of other things. So there's also that, but I digress. And also, it's not unlawful. So there's also that. All right, defendants actively assist and facilitate tracking by designing their guns to enable defacement of serial numbers. Sell me. Defendants can make guns whose serial numbers cannot be obliterated or defaced, or guns in which a hidden serial number will be hard or impossible for a criminal to detect. I don't know. I think they're pretty sophisticated, and we have a thing called the internet. I'm pretty sure if there was hidden serial numbers, people would tell you where to find them. So I'm not sure about that. For example, Bilmer High Point has been including a second hidden serial number on some guns. Many defense guns have been trafficked and covered with obliterated or defaced. Defendants nevertheless refuse to include non-defaceable or hidden serial numbers. Okay, how do you make a non-defaceable serial number? How do you do that? They just say you can. How? How do you make a non-defaceable serial number? I'm not sure, but they think they can. Show me a serial number that cannot be defaced. Let me know when that pops up. Defendants actively assist and facilitate trafficking by refusing to implement reforms they know are necessary. Make it out of diamond and magically bind it to the gun? Yeah, okay, maybe. You know what can scratch a diamond, though? Another diamond? Right? So it's like, yeah, diamond, all you need is another diamond to scratch it. They make diamond-coated bits. If you don't have a serial number, then you can't deface it. I suppose that's true in Cycle Boy. That is true, and I suppose I'll give you a point. I'll give you a point for technically correct is the best kind of correct. That's true. If you don't have a serial number at all, then it is non-defaceable. That's true. You can't deface it. That's true. So you do get a bonus point. Just don't put a serial number on there. That's true. Good work. Good work. You cracked the code. So I guess we can I guess they want us to stop selling guns with serial numbers on them because then they would be non-defaceable. If they want us to stop selling guns with serial numbers on them, let us know. That'd be fine. I don't think that's what they want, though. All right, this is good. An agreement drafted by Smith & Wesson to reform its distribution practice by selling only to authorized distributors, which I'm pretty sure that's all they can do. I mean, I'm pretty sure they can only sell to authorized distributors. And authorized dealers, again, I'm pretty sure that's all they can do. And this agreement by Smith & Wesson says, makes no sales at gun shows unless all sales by any seller at the gun show are conducted only upon completion of a background check. So we're not gonna allow you to sell at the gun show if anyone is selling unauthorized at the gun show. Interesting. Okay, that's interesting. I guess that's a thing. Blah, blah, blah. Blah, blah, blah. Blah, blah, blah. I'm not really feeling this complaint. I'm not really feeling this complaint. I mean, I'm fairly pro Second Amendment, so that might be part of my bias, I suppose, to be fair, but I'm not feeling this complaint. I'm not really feeling like you've shown that they did know or should have known or like actively ignored it or were aiding and abetting in an active like criminal behavior. I'm not sure I really see any of those things from this complaint, to be quite honest. So I think I somewhat agree with the district court who dismissed this. Just hide the serial number on a part that needs a gunsmith. Most criminals aren't gunsmith. Well, we're talking about the cartel. Remember, we're talking about the cartel. That's the whole premise of this thing. I think the cartel could figure it out. If the cartel needed gunsmiths, I'm pretty sure the cartel could find some gunsmiths. So I'm gonna have to disagree with you on that one. If our objective is to stop the cartel, I think they might be able to figure it out, guys. I think they might be able to figure it out. It takes a gunsmith to do it. Wherever will the cartel find a gunsmith? Yeah, sure. Let's go with that. All right, I am tired and I am hungry. But we will be on a little bit later. I need a break. I need food product in my stomach. Okay. Well, this has been a good stream. This has been a good stream, except for, when chat was driving me crazy for a while. And then I think that one guy said something like, well, he's never giving another dollar to the channel because every time he contributed, I disagreed with him and it's like, that doesn't make any sense. And he's like, well, I'm never giving you any money again. I guess I bit the hand that fed me on that one. So that's exciting. Use the metric system? You mean like 9 millimeters? Like that? Or like 5.56? You mean like that kind of metric system? Yeah. Thank you for the $2. All right, I'm going to sign off, and I need some sort of chicken rice dish. I'm hungry. I'm hungrier than I thought I would be. I had some earlier, but I'm actually feeling pretty hungry. So I'm going to stop and pause and make some food, heat up some food, and take a break and try to be on a little bit later. No promises to any particular time. I probably need a couple hours just to regroup. Possibly go to the gym, maybe, if I can get the energy together. I've been Uncivil Law. Until later, my friends. I hope all's well. Cheers for now, my friends, and goodbye.